Old matters. Item number 1.
In this case, I have given a dead chart for my lords.
Lord, there will be little small events are there to be considered by your lordship, my lord. It's a case, the point for consideration would be the criteria for selection of the year of vacancy, whether can be changed for the petitioners, though there was a judgment passed by this honorable court in the subsequent year. It is like this, my lord. 2019, there are vacancies of 20 for the ASI. As per RPF rules, the willingness is to be given by the persons, constables, head constables to appear in the exam in the purpose of promotion. Now, the criteria says that they must have served 10 years as constable or head constables, as the case may be, to appear in the examination for ASI. Now, the training period was the core issue in the earlier judgments passed by this honorable court. Now, the petitioners, they submitted their willingness for the purpose of appearing in the examination. They were debarred from appearing in examination because the training period which they have already served was deducted from the eligibility period of service, means 10 years. So, what happened when the examination was notified on 28/4/2010, some of the similarly placed persons, they approached this honorable court, got a judgment that the training period cannot be deducted from the period of service. That judgment has attained finality. Now, those people, they have appeared in the examination. But these people, these present appellant before your lordship, they had not approached the honorable court. After examination, they approached this honorable court. This honorable court passed a judgment. I'll just show your lordship that operative part of the judgment, Lord, which will be relevant for consideration by your lordship, my lord. That is page 60, my lord, para 8. Lord, this is the writ petition filed by them to take the training period into consideration and give them promotional avenues. Lord, that starts from page 55. The operative part of the order is at page 60 in our considered opinion.
Yes.
In our considered opinion, petitioners are entitled for relief as has been granted in the aforesaid 2 writ petitions, as the said benefit was denied to them in the earlier examination, though some of them are admittedly senior to the petitioners in the earlier 2 writ petitions. Therefore, we direct the opposite party to conduct examination in accordance with law, inviting application from the eligible persons, and after publication of result, the correct place of seniority must be maintained among the persons who will be found successful vis-a-vis the persons who are selected pursuant to the departmental examination on 28/4/2010. But here the direction shall may kindly see, they will conduct an examination. Then if the petitioners are found successful, their seniority will be considered vis-a-vis the persons who are already selected in 28/4/2010. Now, the department was obliged to conduct an examination pursuant to this judgment, my lord. This I am emphasizing before your lordship. Now, what they have done is, after this judgment, my lord, this judgment was passed on 12th of August. Kindly see the date, on 12th of August 2011. Now, for 2009-10 examination, there were all 20 vacancies. The year of vacancy is 2009-10. I am emphasizing that again, my lord. And criteria as of 9-10 will govern the field so far as the appellants are concerned. Now, after this judgment was passed, the department did not conduct an examination. On the other hand, prior to this judgment, they gave a notification inviting application and willingness from all persons. That is on 11-9. Kindly see that notification, Lord. That is page 61. That is on 11-8, page 61. Second line from the second top reference, 11/8/2011. The judgment was on 12/8/2011. They scheduled the examination 21/9/2011. Now, my humble submission here would be, in terms of the judgment, there is no examination. In this examination, the petitioner's willingness were taken, but because the fact that they have secured lesser marking in comparison to these examinees, they were not treated as successful. Now, the point here would be, my lord, those persons who are successful in 9-10 have secured some 68 point some odd mark. And in this examination, we have secured 72 point some odd mark. But question remains, the eligibility criteria of the year of vacancy is 9-10. If at all you would have conducted an examination pursuant to this judgment, then we would have competed with those persons as per the selection criteria of 9-10. Now, you are fitting us in 10-11 examination, saying they applying the eligibility criteria for 10-11 and disqualifying us. Now, in the process, Lord, after this judgment, we again approach this honorable court that you have not considered. One just thing I'll show your lordship, Lord, page 50, Lord, it is relevant. Kindly see page 53, para 13. Lord, in this writ petition, railway took this stand, my lord. In the earlier disposed of writ petition, railway took this stand. Lordship may kindly see para 13. That with reference to para 4 of the writ petition, it is humbly submitted that in view of the judgment dated 28/10/2010 passed in WPC 6671/6672 of 2010 with regard to eligibility criteria, the opposite party felt that injustice had been caused to the petitioners, mean we, my lord, petitioners, by not affording them opportunity to appear the test into the consideration. To afford equal opportunity to candidate of equal status, the opposite party has already prayed this honorable court by way of filing a civil review petition number so and so with a prayer to allow the opposite party to allow to hold a fresh selection, passing the selection held on 28/4/2010. This is the clear stand before this honorable court was by inviting willingness of all eligible candidates, combining the earlier vacancy and vacancy arose so far, or to hold supplementary selection, allowing 186 deprived candidates, including the petitioner who is now before your lordship. This was their clear stand. And on the basis of this, my lord, the judgment I read out before your lordship was passed to hold an examination and consider our seniority qua the persons who have been selected on 28/4/2010, the crucial date. Now, when they were not allowed in the other examination which was conducted without prior to the judgment passed by this honorable court, we are not selected. We approach this honorable court again. Now, the honorable single judge passed the judgment considering that what they have done is 2009-10 residual vacancies were 8 vacancies. Now, in 2010-11, 21 vacancies were there. They clubbed up these 2 years vacancy together and conducted the examination. Now, the honorable single judge has held that the year of vacancy is 10-11, whereas residual vacancy of 8 were tagged with 10-11 and examination was conducted. And that is how the honorable single judge has dismissed our writ petition, saying that since 2010-11 examination you are not successful, we do not have a genuine claim. Kindly see that part of the judgment, my lord. Yes, my lord. Page 30, running page 30, internal page 10.
Yes.
My lord, in this middle paragraph, in the event that the selection process for the vacancy of 9-10 was conducted by preparing merit list on 30th of April 2010, while the petitioner has approached this court by filing also on 4/2/2011, that is after delay of 10 months. The petitioners, however, have been allowed to participate in the subsequent selection process, which has been initiated by asking willingness from one or the other candidates who are desirous of participating in the selection process for filling of the vacancies of the year 11-12, which was 29 for that particular year, and 8 backlog vacancies which are not filled up in 9-10. So what I'm trying to address your lordship from this is, for 9-10 vacancies, the criteria, whatever cutoff mark was there, we should have been considered qua that. These are the vacancies of 9-10 were clubbed together in 10-11, and prior to the judgment passed by this honorable court, all these events have taken place. Now, Lord, I have only 2 precise submissions, Lord. One, the criteria for 9-10 should have been taken into consideration so far as we are concerned. The recent judgment of this honorable court is there, Supreme Court is there, my lord. Para 44, my lord. It is evident, may be permitted to, I'm sorry, 2019-16 SCC, page 28. Para 24, sorry, para 44.
Yes.
It is evident from part 5 of 2001 rules, of course, governing that particular rules where the case was being considered. More particularly, the rules governing promotion containing Rule 34-35, that the deeming fiction envisaged in Rule 35-6 applies to the promotions made under the auspices of a DPC. In the case of such promotions, Rule 35 mandates that the committee constituted under Rule 34 must consider the cases of persons who are eligible in the year to which the vacancy relates, irrespective of the year in which the meeting of DPC is held. The underlying rationale for Rule 35(6) is that on the determining year-wise vacancies, rights are crystallized with reference to the year in which the vacancy has arisen. Consequently, the delay on the part of the DPC in convening its meeting should not result in prejudice to those candidates.
Mr. Rathar,
Yes, my lord.
holding a DPC is very different from holding an exam.
Correct.
We can't draw parallels like this. DPC, there's always an issue that which year's DPC are you holding?
Correct.
The exams is very different. So every exam is a different exam.
Lord, here was a case of DPC and ours is a case of exam.
No, very different.
Exam, your lordship may kindly see the distinction here. What they should have done, whether they have acted in terms of the judgment at all. Kindly see the again, Lord, at the cost of repetition, I request your lordship to see that para of the judgment. On 12(8), this honorable court says that you conduct an exam. Consider our case, those persons selected on 28(4).
See, it so happened your exam obviously was a tougher exam. The cutoff in your exam was a tougher cutoff. Because you are now competing with a different set of people. If you're competing with the same set of people who were
9-10, Lord.
That's it. If you see, you approach the court late. What the important fact you're missing out is some people took the lead, went to the court, got an order in their favor, sat for the exam. You people, for some reason, missed the bus on that occasion. Later you woke up, later you went.
And Lord, we are protected by this honorable court.
No, protect only to the extent saying they sat for exam, you will also sit for an exam.
Correct, man.
What you're now saying is their whatever standard on which they were tested is different from the standard on which I am tested.
May I make a submission to draw a balance in this matter. Since 2010, these people are languishing without a single promotion. Lord, Lord, they are.
I'm sure.
But I'm just suggesting a proposition.
No, what about ACP and all will be there?
No, my lord, they are all head constables till date, 10, 12 years, they have not been given any benefit of promotion, my lord. I am just suggesting, my lord,
all right,
subject to if others will agree, without affecting these people who are already continuing senior to us now. Lord, if the department can consider for us for a notional promotion without claiming any financial benefit or seniority.
That's a policy decision.
Lord, they should, I am
it's
just
like an ACP.
Yes,
it's an assured career program.
Yes, my lord. They should, if they can consider our case in that regards, my lord, that would be, my lord, without
that's all right. I don't think any to consider whether you want to formulate a policy for them that nobody is asking you to consider.
Railway will say.
In
this case, my lord, what has happened? I have certain different case, my lord. Let railway will.
If that is the proposition, they will advance, my lord. I don't think there will be any contesting issue.
The petitioner faced the examination. They could not succeed, my lord. And so far, putting the petitioner, the seniority, my lord.
No, he is not claiming seniority. No. He's only saying, give me some promotion. He's now even giving up seniority.
The authority will consider their, my lord.
Any notional promotion without claiming any arrears of pay or seniority.
Yes, I agree.
Without claiming seniority.
Without claiming seniority and financial benefit.
But the order is to give them seniority if eligible to get appointed.
That is the similar course, sir.
Yes.
Now that will not work, he's suggesting that why don't you give me a one-time notional promotion?
Yes.
With that
it's like an assured career progression, sir.
With that observation, Lordship,
all right.
My case is different.
Which is your case now?
WA 317 of 2018. Last. My lord's notice page 19. This was the notification dated 13/10/2009. The vacancies, 20 vacancies of the year 2009-10. We approved my lords, the lordship directed, and we participated. We are selected that your lordship page 33. My name finds place in the select list of 12 candidates. That is the date. Your lordship, that date is important. 8/8/2011. After our selection, that another notification was made. That annexure 4, page 35. Your lordship has seen it. Page 35. Your lordship, that is the date 11/8/2011. This is 29 vacancies. These are the vacancies of year 2011 and 12. Some candidates, they have appeared in response to this notification, and their result was declared. Let me see page 55, my lord. Annexure 10, your lordship, page 55.
2 months after your
My lord.
2 months after your result. Your
Yes,
result
yes,
was in
yes.
August. This is in
Yes.
October.
Yes, ma'am.
Ah,
This is 28/10/2011, and
Ah.
this is in respect of vacancy of 2010,
10,
11, 12, and we are
9-10.
9-10. What they did, they clubbed the two lists and fixed intersectionality among the 2009-10 and 2011-12. That is the dispute here.
What does the single judge say on this?
Honorable single judge said, since the earlier judgment said that two merit list will be prepared and the intersectionality will be fixed, so there is no irregularity in this. Entire case, your lordship has seen that they have not conducted the recruitment test in proportion to my lord's direction. Because they have conducted the recruitment test prior to the judgment passed by my lords.
No, not prior. No.
Yes, 1 day prior.
Yes,
Yes,
No, the notification was issued 1 day prior. Sir.
Yes, ma'am.
Not the test.
That's not the test. They have issued that notification prior to that.
Ah.
But that if they will conduct that recruitment test in proportion to my lord's direction, there will be vacancy of 8 vacancies, not 29 vacancies.
But how many of you? You're more than 8.
No, we are selected, my lord.
No. How many of you?
We are 12. First, your lordship has seen that Annexure 3, my lord.
You're 11 people.
Yes, my lord.
So how can you fit 8 vacancies?
No, I am not wanting to be fitted against 8 vacancies. We elected against 12 vacancies. Out of 20 vacancies, 12 candidates were selected. I was among them. Your lordship, Annexure 3, page 33.
So how many of you are? You're a single person.
No, not single. We are before my lords, my lord. 2 persons.
What about the rest in your batch? They're not bothered about seniority.
No, they have also filed approach, my lords. We are fighting, my lord, because our seniority is to be affected.
What is your reply here?
My lord,
For seniority, sir, every year has to be a separate
Yes.
seniority. You can't club different years.
my lord, though there was a committee constituted, your lordship may kindly glance at page 82 of the order. A committee has been constituted by opposite party to look into the matter of for fixation of interest seniority. As such, decline to interfere with the decision of the authority. So, committee
It says seniority has to be for these 12. You can't club it with the
Yes.
people who qualify in 2 months later.
though the committee has constituted, therefore the club.
How can you club? But he has to do it batch wise, sir. Can't club.
They obtain instruction to that effect.
No, we'll set aside. You redo the exercise now. All right. Let's do 317 first. Writ Appeal 317 of 2018. The present appeal is directed against the judgment dated 27th April 2018. Passed by the learned single judge. In writ petition civil 14022 of 2012. Paragraph. The background facts are that both appellants are serving as head constables, is it?
Yes, ma'am.
In the Railway Protection Force, bracket RPF. First of, under Rule 72 of the Railway Protection Force Rules 1987, bracket RPF rules, bracket. for consideration for promotion to the post of Assistant Sub-Inspector of Police, bracket ASI, bracket in the RPF. The candidate has to be a constable who has completed 10 continuous years of service. Stop. Initially, in the selection process initiated on 22nd March 2010 for filling up 20 vacancies in the post of ASI for the year 2009-10, the present appellants were not allowed to participate on the ground that, excluding their training period, they did not complete 10 continuous years of service as constable. Full stop. The appellants then filed petitions civil 6671 and 6672 of 2010 in this court. Full stop. In the said writ petitions, an interim order was passed on 13th April 2010, allowing the appellants to participate in the recruitment test. Full stop. The said writ petitions were finally disposed of on 28th April 2010 by a division bench of this court. Directing the authorities to publish their results and consider their candidature for the post. Stop. The petitioners in the said two writ petitions were selected and promoted to the post of ASI and thereafter sent on training. Paragraph. Another set of employees similarly situated as the petitioners in writ petition civil 6671 and 6672 of 2010 again filed writ petition civil 2558 of 2011. So the said writ petition was disposed of by a division bench of this court on 12th August 2001, holding that the said petitioners should be granted the same benefit as was extended to the petitioners in writ petition civil 6671 and 6672 of 2010. Full stop. A direction was issued to the opposite parties to conduct an examination in accordance with law, inviting applications from eligible persons, and after publication of result, to maintain the correct position of seniority amongst those found successful vis-a-vis those who were selected earlier pursuant to the exam held on 28 April 2010. Paragraph. It appears that one day prior to the said judgment, that is on 11th August 2011, a notice was published by the opposite parties announcing the initiation of process of selection for promotion of constables and head constables as ASI. Full stop. The number of vacancies announced no, you just say It appears that there were 20 vacancies, is it?
29 vacancies.
29 vacancies. For the year
2011-12.
11-12, for the year 2011-12. And 8 vacancies for 9-10, is it?
21 vacancies at 2011-12 and 8 carried forward vacancies.
29, all 29 vacancies, of which 8 vacancies belong to the year 2009-10 and 21 to the year 2010-11. Full stop. As far as the present 2 appellants were concerned, in the result published on 8th August 2000,
Yes, my lord. 8th August 2011.
which page is that?
8th August, page 33, my lord, next to 3. 8th August 2011.
They were among the 12 successful candidates. But tell me one thing, this is on 8th August 2011.
My lord.
Exam for this was held when?
Exams, my lord.
29. 21st of September 2011, that is at page of my.
So this exam was held pursuant to the earlier judgment of 28th April.
Yes, ma'am.
Just show me, just tell me what. No. Just tell me.
Examination was held on 28/4/2010. Your lordship can find it from my date set at serial
No,
number
the
8.
judgment is 28.
No, judgment was that to publish the result, my lord. We have in compliance to the interim order, we have appeared in the recruitment test. Thereafter, your lordship directed to publish the result. As per the interim direction, we are allowed to participate.
See, among the 12 successful candidates, it may be noted here that the said exam was held pursuant to the interim orders passed by the High Court in Writ Petition Civil 6671-72 of 2010. And the final result was published as a result of the judgment dated 28/10/2010. And an order passed subsequently on 3rd August 2011 in contempt number 252/253 of 2011. Full stop. As far as the selection that took place pursuant to the subsequent judgment dated 12th August 2011 of this court is concerned, it appears that a separate list was published on 28th October 2011, in which 29 candidates who were successful were notified. Paragraph. The grievance of the present appellants is that when it came to fixing the interstate seniority in the rank of ASI, the opposite parties, oblique railways, East Coast Railway bracket, clubbed both the list of 12 published on 8th August 2011, along with the list of 29 published on 28/10/2011, and then determined the interstate seniority. Full stop. The case of the present appellants is that since they were to be considered against the vacancies for 2009-10, but they could not have been clubbed together with the 29 persons who were to be considered for the vacancies of 2010-11.
Well,
This interstate seniorities list is 18/1/2012.
well. It's 57.
It may be noticed here that the interstate seniority came to be published on 18/1/2012. On final completion of the successful completion of the training of all of the selected ASIs. Full stop. In the writ petition, Civil 14022 of 2012, filed by the present appellants. 4 appellants. There are 4 petitioners, of which only 2 have filed an appeal.
My friend appeal to has come, so I filed.
Okay, filed by the present 2 appellants along with 2 others. The prayer was for a direction to the ECR to fix the seniority of the appellants by treating them as promotees of the 2010 batch, and to treat opposite parties 2 to 16 in the said writ petitions as promotees of the 2011 batch. Now, who's appearing for them here?
My lord,
For the private opposite parties, private respondents.
nobody appeared.
Respondents 2 to 16. Somebody must be appearing for them. Dhanuj Kumar Sahu.
From wisdom.
It was for one. For one. Only- at
No,
that
no.
time,
1 to 16 it says here. It was for 1 to 16 it says. No, but it's for only the railway section.
Only
In fact, he has not filed Wakalatnama. Problem, sir. The private respondents are not there.
Lordship has issued notice on 9/4/2000.
Then what happened?
They have not appeared.
No, no, have they been
Even they have not
served?
also appeared before the honorable single judge.
No, no, no. There's no indication whether they were served or not.
It is senior counsel perhaps appearing for them. KP Mr.
See, unfortunately, it simply said reflect the name
How
of.
can it appear in relation to seniority?
Sorry.
Not appearing. Because I'm not promoted at all. If your lordship will permit me, I can make two submissions.
You are for 2 to 16.
No, I'm in writ appeal number 304 of 2018.
No, we are in 317, sir. Just a
I'm
few
sorry,
minutes.
I'm not appearing for the opposite parties.
No, anyway. So who's 317? There's nobody. They have to be heard, sir. They are the main affected party. We wanted them to be treated as a separate. Their seniority will be affected. Without hearing them, we can't take off this whole thing now. This separately, you say it's writ appeal 317 of 2018, separate order. You see, the present petition concerns the interstate seniority between the two appellants and the private respondents 2 to 16 in the rank of Assistant Sub-Inspector of the Railway Protection Force. Paragraph. It is seen that although notice was issued by this court in the present appeal on 9th April 2021, there's no indication that notice has been served on respondents 2 to 16. Full stop. Appearance has been entered only on behalf of the East Coast Rail respond number 1 by Mr. S.R. Patnaik, advocate. Full stop. Paragraph. Fresh notice will now issue to respondents 2 to 16. 17th April. Then in the other writ appeals, which one are you appearing, Mr. Shah?
304, my lord. 304 of 2018.
You're for the appellant.
I'm for the appellant.
No. So Mr. Ratha was appearing for similarly placed appellants.
Yes, my lord. I'm similarly
proposed,
placed, but my contention would be very limited, my lord. I have a right to appear in 2009 and 10 against the vacancies of 2009 and 10.
Right.
Promotion is not a matter of right.
Correct.
But consideration of promotion of all eligible candidates are matter of right.
Right.
Promotion is not a matter of right, but consideration of all eligible candidates to sit in the examination is a matter of right.
Right.
Which were denied to us by the authorities. That after your lordship decided that we are eligible. It is not confined to the petitioners, those who had appeared against 2009. They said 10 years will be concluded, including the training period. So consequently, we are also eligible to sit in the examination, which we were deprived.
So
Therefore,
the problem is you people did not join the first set of written petitioners.
Merely because we are not filing written application cannot take away right for consideration against the vacancy.
It's hard to say. It's hard to say that, sir.
That is my contention. That I have a right for consideration against the vacancies of 2009 and 10. Consequently, this honorable court directed for a fresh examination and through the vis-a-vis the seniority, and we have secured much higher marks than the batch of 2009 and 10.
No, but not high enough in your own batch.
That's
Right.
My contention is we are also eligible for consideration, which were denied, and thereby we have been deprived for promotion, for seniority, for everything.
All right.
That is my limited contention before lordship.
All right. Now, all other writ appeals, you see, these writ appeals are directed again. The common judgment dated. 27th April 2018, passed by the Land Single Judge. In the writ petitions filed by the appellants, bring for a direction to the opposite party, East Coast Railway, bracket ECR, to give promotion to the appellants to the post of Assistant Sub-Inspector, bracket ASI, of the Railway Protection Force, bracket RPF, on the same date that the private respondents were so promoted, with all consequential monetary reliefs. Paragraph. The background to the present appeals is that all the appellants have been serving either as constables or head constables in the RPF. We'll stop. In terms of Rule 72 of the Railway Protection Force rules, bracket RPF rules, in order to be considered a promotion to the rank of ASI, a constable had to complete 10 years of service. Full stop. The case of the present appellants was that although they had submitted their willingness to participate in the selection process, they were not allowed to do so since, after excluding the period of their training, they did not complete 10 years of continuous service. Paragraph. One set of constables filed writ petition civil number 6671. So one constable, it's only one of them, is it?
Right, madam.
One constable,
Yes, madam. Gadadhar
Shri
Mahapatra.
Gadadhar Mahapatra,
Right.
filed writ petition civil 6671 of 2010 in this court, challenging the action of the ECR and not letting him participate in the selection test for promotion to the rank of ASI, which had been scheduled to be held on 21st April 2010. Full stop. By an interim order dated 13th April 2010, he was allowed to appear in the selection test. And it was directed that the result of the test would be subject to further orders to be passed by the court. Full stop. The writ petition came to be finally disposed of by a division bench of this court on 28/10/2010, accepting the plea of the said petitioner that his training period should be included for the purposes of the 10-year eligibility period for being considered for promotion. Full stop. The recent appellants who were similarly placed then filed writ petitions seeking similar relief in terms of the judgment dated 28/10/2010 passed by this court in writ petition civil 6671 of 2010. Full stop. The said writ petitions were disposed of by a division bench on 12th August 2000. Granting relief in the following terms. Just take page 60 in writ appeal 294 of 2018, para 8. The entire para 8. It must be noted here that present appellants all considered themselves to be eligible to be considered for promotion against the vacancies in the post of ASI for the year 2009-10. Full stop. By the time the above order came to be passed by the division bench of this court on 12th August 2011, there are also vacancies in the post of ASI for the years 2010-11. Paragraph. One day prior to the judgment of this court, that is on 11th August 2011, a notification was published announcing selection for the promotion to the post of, announcing the test to be conducted for selection, announcing the selection test to be conducted for promotion to the post of ASI. Full stop. Pursuant thereto and pursuant to the judgment dated 12th August 2011 of this court, all the present appellants sat for the selection test. Full stop. However, they were not found to have qualified on merit.
But would not be successful. But can I just interrupt? Can I just say, they all passed the test.
I know.
They qualified, but would not be successful in the merit test.
That's right. Okay. They all, you say, although the appellants passed the test, they were found to have scored lesser marks basing on the merit position of all the candidates who took the test. Full stop. Paragraph. Before the learned single judge, an argument was advanced that in the selection made for the vacancy year 2009-10, the last selected candidate had secured 68.8 marks out of 100, whereas all the appellants who took the subsequent selection test scored 73 marks and above, and definitely therefore above, were of a higher merit than the last selected candidate in the selection held for the vacancy year 2009-10. Full stop. Contending that they should have been considered against the vacancies for 2009-10 and assessed on the same basis as the candidates who had sat for the test for the said year. They claimed that they should be placed, they should be granted promotions as ASI. Full stop. The learned single judge has in the impugned order noticed that the appellants had scored 72.42 and 69.58 marks. The appellants had scored marks less than the last selected candidate in the selection held pursuant to the notification dated 11th August 2011. Full stop. In that selection, the last selected candidate secured 72.45 under the unreserved category, whereas all of the present appellants had scored less than that. The learned single judge did not accept the plea that they did not accept the above plea of the appellants. Since the selection held pursuant to the order passed with this court on 12th August 2011 was a separate exercise, and the merit position in the said selection exercise could not be fixed on the basis of the performance of the last selected candidate in the earlier exam held for the vacancies of 2009-10. Full stop. It was rightly noted by the learned single judge that, for reasons best known to them, the present appellants had not come to the court at the time when the petitioner in petition civil 6671 of 2010 approached it. Full stop. They became alive to the possibility of being considered for promotion as ASI by including their training period for the purposes of calculating the 10-year period of eligibility as constable only after the judgment of the court, only after the judgment dated 28th April 2010. Is it 20th April or 20th October?
Not that is.
20th October 2010. Full stop.
28th October 20.
It was only if they were successful in the subsequent selection test held pursuant to the notification dated 11th August 2011 that the inter se seniority could have been arranged vis-a-vis others, the earlier successful candidates, in terms of the judgment dated August 2011. Stop. Fair enough. Mr. P.K. Rathul, learned counsel for some of the appellants, sought to rely on the judgment of the Supreme Court in Ganga Vishan Gujarati versus State of Rajasthan, 2019-16 SEC 28, to urge that the present appellants had to be considered for the purposes of merit in the selection test on par with those who took the selection test for the vacancies of 2009-10. Full stop. However, the court notes that the said judgment dealt with promotions being made under the auspices of a departmental promotion committee, bracket DPC, where promotions were considered in relation to vacancies of a particular year, irrespective of the year in which the TPC was being held. Full stop. That is a very different principle and does not involve holding of selection tests for the purposes of promotion. Full stop. Therefore, the aforementioned decision is of no assistance to the appellants here. Paragraph. Mr. Kaliprasna Mishra, the senior counsel appearing for the appellants in WA 304 of 2018, submitted that the appellants were unfairly denied the chance of being considered for promotion on par with the successful petitioner in writ petition civil 6671 of 2010. Full stop. According to him, therefore, the ECR was obliged to extend the same benefit as was extended to the successful applicant, a petitioner, in the said writ petition, to all the applicants who may not have approached the court at the same time. Paragraph. Here again, the court is unable to agree with the aforementioned submission. Full stop. The fact remains that the present appellants did approach the court, but at a different point but a subsequent point in time. And in their cases, the division bench of this court passed a separate judgment on 12th August 2011, the operative portion of which has been already extracted here and before. To stop, that only required the ECR to hold a separate selection test where the present appellants would participate. Full stop. This court did not order that the evaluation of the performance of the present appellants would be on the basis of the last selected candidate of the earlier selection test. Full stop. In that sense, therefore, what the ECR has done is to strictly go by the directions issued by the court in its judgment dated 12th August 2011. Full stop. The court is therefore not able to accept the plea that the present appellants were unfairly denied the right to be considered for promotion on par with the successful petitioner in writ petition civil 6671 of 2010. Paragraph. Finally, it is submitted by both Mr. Mishra and Mr. Rathar that since the appellants have remained as constables or head constables for many, many years now, with no promotion whatsoever having been received by them, a direction should be issued to the ECR to consider the possibility of giving them a one-time notional promotion without the appellants laying any claim either to arrears of pay or to seniority. Full stop. As far as this plea is concerned, since it is a policy decision that would have to be taken by the ECR, the court, while declining to interfere with the impugned order of the single judge, direct that the respondent ECR will consider the above plea of the appellants for being granted notional promotions as ASI, without any claim to seniority vis-a-vis the private respondents or without any claim to arrears of pay. Full stop. A decision on this aspect by the ECR be conveyed to the appellants within a period of 3 months from today. Full stop. The returns are accordingly dismissed.
I don't have to
All appeals are disposed of.
All the appeals except Mr. Pooty.
Except that one.
That's
I'm in 312.
got it.
Item number 2,
May I please, your lords? Mala, I am the opposite party. Mala, I am the bank.
All right, none appeals to the appellant. Dismissed.
I-
item number 3,
May I please, your lordship? This is the appeal indicated against the order passed by the Honorable Single Judge dated 6th of August 2019. The present appellant was working as revenue inspector in the Odisha State Cashew Development Corporation, has paid in the writ application for grant of his revised scale of pay in terms of the Odisha revised scale of pay 2008. Now, pursuant to that, your lordship may kindly see Annexure 1 at page number 12 of the appeal. On 2nd of March 2009, the Revenue and Disaster Management Department, they have revised the scale of pay of the revenue inspector from 5,000 to 8,000 and grade pay of 350 to 4,590 to.
So anyway, you have to, the only ground on which it was rejected was delay and latches.
Yes, your lordship, but my
What's the
humble
explanation for that?
yes, your lordship. My humble submission is pursuant to that, in the first round of the board resolution, the chairman has decided that the revised scale of pay will be granted to me. Now they have sent a proposal to the government, they have rejected it. Now, pursuant to that, there was another board resolution, your lordship, which the Honorable Single Judge has not considered. I will show it to your lordship. That is at page number 34, your lordship, of the writ petition. Page 34, your lordship. And 8 series of the writ petition. And 8 series of the writ petition. That is the proceedings of the 167th meeting of the Board of Directors Odisha State Cashew Development Corporation Limited, held on 24/5/2011. Now, at the next page, your lordship, at page 35, item number 167/14, at
Yes.
B, the chairman pointed out regarding approval of the revised pay scale of rupees 9,300 to 34,400 with grade pay of rupees 4,200 in pay band 2 under ORSP Rule 2006 in favor of revenue inspector of this corporation. During this discussion, managing director apprised the board that as per resolution of 165th meeting, the board of directors held on 23/11/2010, government in agriculture department was requested by this office letter number so and so, it is 7/2010, to accord necessary approval for confirmation of the pay scale of rupees 900 to 32,400 with grade pay of rupees so and so. My humble submission is, your lordship, even if the government has on the first round, they have declined our request, but on the second round, again the board of directors, they have held a meeting. They have concurred that I will get the financial benefit of the second pay band. Now, pursuant to that, your lordship may kindly see on various addition 9 series. On 2012, the managing director has sent a proposal requesting them to grant me the revised scale of pay in 2012. Now, again on 2015, lastly on 2018, it is prior to my date of retirement. That is at page number 27, your lordship. 26 of the writ appeal. It is prior to my date of retirement. But this is relevant, your lordship. I am saying so.
No, just going on making representations neither here.
Not me, your lordship. Not me. But
whoever, sir.
Yes, your lordship. But my only contention, which was ignored by the only single judges, all the other revenue inspectors in the Parametrica Corporation, they're getting the benefit of pay band 2.
No, the question is, when do you come to the court?
My lordship, after my
You came in 2019.
yes, your lordship, after my retirement.
This
After
what
my
is showing
retirement.
us is of 2011.
No, on 2011, that was a board meeting decision, your lordship.
Correct, but you can't wait for 8 years to then come to the court.
Because of their timing again, they were sending proposal, my lordship. The government didn't take action. After that, I come to this court, your lordship. Actually, for a moment, kindly see.
Can't wait endlessly, sir. You know that latches, the whole principle of latches is that.
But my lordship, when the board of directors, they are taking decision on my behalf.
In
They are
2011, sir.
18, your lordship. And
That is just a reiteration.
Annexure 6 series, your lordship, page 26 of the writ appeal. It was 2018. 2018, your lordship.
No, this is just a letter.
In terms of the resolution, your lordship,
That's
passed by the board of directors. Now they've categorically stated that all the other revenue inspectors in the other corporations, they're getting the benefit of OSP rule 2008 in the pay band 2. What they have done is, in my case, your lordship, I being a revenue inspector, they are giving me the salary of a ARI.
Who's for the respondent?
As I appear for the
Ah. What are your instructions?
As the single judge.
Notice is not gone in this so far.
No, this is the.
All right. Notice return. 17th April. All right.
Item number 4.
This case arises out of silly proceeding under the Odisha Reliance Act.
What's the delay?
But the case is that the Sum case was initiated against Radhanath Bevrata Patnaik of Atagor. Taking is a shilling holder under section of 42B of the Ola. And although the land belongs to himself and other his wife, and his wife has not noticed, his son filed objection that was not accepted, and thereafter during the pendency of the selling proceeding, the shilling holder and his wife dead. Therefore, my ambition is that the selling proceeding is nullity. Because the appellants.
I'm not able to. I have no idea what is.
The appellants were neither implicated by it nor suspended nor. But the appellants, after knowing about the selling proceeding, they filed revision case before the LIC to refer the matter to member board of revenue for revision, because they are not party to the proceeding, and the selling proceeding is a nullity because the selling holder is dead. During the pendency of the proceeding, selling proceeding, he was dead. And that too also, the urban area of 4 villages were implicated in the selling area.
Take steps for limitation. What happened? And you have to remove defects. Nothing you've done.
10 days limitation. That is my miscalculation. Only 10 days limitation. State is the other side.
Still, you have to at least file an application for continuation.
Already, I will permit to file application. 10
Defects
days only limitation.
Defects be removed as a last chance within a week. List that out.
Item number 5.
In this case, I have to challenge the order of a single judge who has directed that the encroacher who are encroaching land by the side of a railway quarters of Berhampur, they have to be rehabilitated in cooperation with the state government. That is the order I have challenged all the 3, 5, 6, and 7.
109 days. Wow. You want to address the issue of limitation, sir?
My lord,
Do you want to address the issue of limitation?
limitation, 4 months limitation there in case. Where the government had to take decisions to file the order. But the rehabilitation by the side of the railway quarter, they are encroaching, and the direction is that in connection, in cooperation with the state government, a rehabilitation scheme is to be
What
framed.
is wrong with that? Nothing wrong
My
with
lord.
that. What is wrong with that?
But the government has to give railway land is not sufficient, my lord, and government has to give land so that we will see to it.
Correct. You say there's a delay of 109 days in filing the writ appeal, which has not been properly explained in the application for coordination of delay. So what is set out is only the routine administrative delay, which has not been accepted by the Supreme Court. And in a series of judgments, including Living Media, same thing, and State of Madhya Pradesh, Perula, paragraph. Nevertheless, consequently, the court is not inclined to condone the delay in filing the writ appeal. Paragraph. Nevertheless, the writ appeal has also been examined on merits. The only direction issued by the single judge is for the present appellants. Is for the state authorities to cooperate with the railway authorities in the matter of rehabilitation and resettlement of the writ petitioners. Who had questioned the orders of demolition passed by the railways of their constructed thatched huts. So the court sees no prejudice being caused to the present appellant by the aforementioned directions.
6 and 7 similar matter.
All right. The writ appeals accordingly dismissed both on the grounds of delay as well as merits. 6 and 7, same thing. All right.
Item number 8.
May I please? But the limitation is only 2-3 days, my lord. I'll only file the application. Covered by your lordship's judgment. Lordship, what happened, my lord? The appellant is just renewable energy. What is a renewable energy and development agency?
Last opportunity to remove the defects within 1 week, list thereafter.
Lord, I filed the petition today. If lordship,
whenever, sir, no problem. Whenever you remove the defects, it will be listed.
Exactly.
Same for 9 also, sir.
9 limitation is not there, I think.
So defects are there, sir.
Defects. I'll remove this.
So 8 and 9, same order. Right.
Yes.
10.
Please, Lordship, my lord. Here, my lord, the limitation period is 1 month, my lord. The delay of filing of WA is 1 month, my lord. Here, my lord, my humble permission before your lordships, my lord. This writ appeal has been filed challenging the judgment passed on 9/7/2019, my lord, in WPC number 5279 of 16, my lord. The Honorable Single Judge, my lord, allowed the dispose of the writ petition in a separate ground. That my humble submission that when the respondent has filed a writ application, sorry, my lord, the respondent filed a writ application challenging the order of commissioner order only on the ground the Hal ROR was wrongly recorded in the name of appellant, my lord. But the commissioner rejected that revision case on the ground that the present appellant, who had the opposite party before the commissioner, was a scheduled caste person. The respondent has not taken any permission from the Oiler authority before purchasing the suit land. So he dismissed the said revision case. Against that revision case, the respondent filed a writ application. But the said writ application was disposed of in a separate ground, my lord. If your lordships kindly permitted me to place that order, my lord, that is annexure 2, page 15, my lord, towards the last paragraph, my lord. Last paragraph, Learned Counsel for petitioners is right in his submission that petitioners cannot be evicted without due process of law. No proceeding has been initiated against the petitioner under the OLR Act. In the event the proceeding is initiated, is open to the petitioner to resist the same. Here, my lord, the petitioner in the writ application challenging the order of the commissioner, but the Honorable Single Judge should have whether allowed or dismissed, that is separate thing, but dispose of only on separate ground, my lord. As per the decision of our this honorable court, my lord.
How was it prejudice to you, sir? How is it prejudicing you?
My lord, because in this case, my lord, I am in possession, but he stated that he is in possession, my lord. So the law and civil judge, that will be decided, my lord, that will be decided by separate court, civil court, my lord. But here, when the honorable single judge has decided that case, the petitioner is right in his submission that petitioner cannot be evicted. That will be prejudice to me.
All right.
Because
All right. Notice returnable 18th April. Notice on the delays. How many? 1 week, is it?
my lord, 1 month.
Delays controlled. All right.
Oblige, my lord.
Meanwhile, the defects pointed out be removed. All right.
My lord, grateful, my
11,
None appeals dismissed.
12,
None appeals dismissed.
11 item. Item 11.
It is called out, sir. No.
Sorry, my lord.
Please come.
My lord, this matter relates to interest seniority in the rank of associate professor in Acharya Harihar Regional Cancer Center. The appellant challenging the order of honorable single judge. My lord, the appellant was initially the appellant was appointed as a lecturer on 7/10/2003 in Acharya Harihar Cancer Institute, and he was promoted to the post of assistant professor on 8/7/2007, my lord. My lord, first vacancy of associate professor arose on 5/9/2017 on retirement of Dr. D.N. Singh. My lord, the appellant was found suitable for promotion to the post of associate professor in radiotherapy on 16/10/2012. During October 2012, my lord, appellant was found eligible and was recommended by the selection committee for promotion to the post of associate professor. By then, my lord, the respondent number 6, who was a directly and appointed in pursuance to open advertisement, my lord, she was not joined, my lord. She joined, my lord, just before 4-5 days of my joining. And as for my lord, regulation 21/22, my lord, first promotion should be given if the incumbent is eligible, but without considering my seniority. The respondent number 6 was given, declared senior, my lord. Against them, I made a representation. The petition appellant made a representation. Your lordship, kindly see the noting I have obtained from the Information Act from the government. That is page 52, dated 25/7/2012. Page 52 of the writ appeal, my lord. May I read, my lord?
So you are saying deliberately they just gave you the promotion letter 1 week later?
My lord, because her husband was joint director in the director of medical education and training.
Otherwise, both of you were selected on the same date, 16/10.
16/10, my lord.
Yes, she was asked to join on 7th. You were asked to join on 14th.
Because she was in earlier cadre, different cadre. She should be at Cuttack, my lord.
Selection committee, 16/10, they told to select. Both are elected. This woman was asked to join on 7th. She had joined on 14th. And they say she joined on 7th. She's senior. All right, note is returnable.
Well,
Sir, I'm the appellant and appearing in person.
Yes.
My counsel is out of headquarters, owing to the accident he met 2 months ago, and there is a post-surgery complication.
All right, counsel, the appellant is stated to be unwell. Defects be removed. Ask him to remove the defects. So there's only 1 or 2 defects.
Yes, sir.
Please ask him to remove the defect.
Yes.
Defect be removed within a week. Please thereafter.
happening on the 14 no instruction.
All right. The memo record dismissed on account of no instructions.
15.
None appears dismissed.
16.
Item 16, I am in DC, my lord. Am I audible, my lord? Item
Yes, please. Yes, please.
There is a delay, my lord, that is of 56 days.
What's the matter about, sir?
Matter is, my lord, regarding allotment of a shop room, and which was, my lord, in a review application after almost nearly 20 years, the allotment was cancelled. My grievance is that, my lord, under Municipality Act, there is no scope for review.
26 days.
So the delay is 626 days.
Again. My lord.
Maybe, what are you saying? Earlier you said something else.
656 days.
What is your explanation, sir?
Explanation, my lord, this lady is a widow and from Koraput. In 2018, my lord, order was passed. She tried to contact her counsel but could not reach her. And after, on her own effort, she could, my lord, know that about the order. And thereafter, she, my lord, in paragraph.
Not very convincing, sir. Very convincing. You see, there's a delay, inordinate delay of 656 days in filing the present appeal. The explanation offered in the application IA 1957 of 2019 for the delay is neither satisfactory nor convincing. The court is accordingly not inclined to condone the delay. IA number 957 is dismissed. Consequently, the writ is dismissed.
17.
No instruction.
No instructions dismissed. All right.
18.
None appears dismissed.
19.
19, my lord, infractious, my lord.
Infractious dismissed.
18, my lord, it is RPF matter.
You are for the appellant, sir, in 18?
On an opposite party, man.
Just put in the appearance. All right.
20.
My lord, this appeal petition filed by the department by challenging the order dated 10 December 2010 under Annexure A4 passed by the Land Tribunal Customs Access Service Tax Kolkata by satisfying the order in appeal dated 4th March 2010, my lord.
Tell us what the matter is about.
Well, he the respondent during the period from April 2005 to August 2008. The assessee purchased and bought 1,58,078 metric ton iron ore and 1,66,939 metric ton of coal for use in their factory for manufacture of sponge iron. In the process, they paid the freight to various transporters toward the transportation of iron ore and coal into the factory, paid service tax on the said freight, and in turn availed the service tax so paid as credit and utilized the same toward the payment of central excise duty on a clearance of their final product. It was noticed by the department that though the central credit has been availed in respect of GTA service on the raw material, instead of utilizing the entire raw material for manufacturing of final product, a quantity of 8,467.60 MT of iron ore
So what has happened?
and a quantity
Sir, come to the impugned order, para 6,
My lord.
page 40.
My lord.
There's a reference made to a judgment of the tribunal in Chitrakoot Steel and Power Private Limited.
My lord.
Was any appeal filed against that judgment?
My lord.
Yeah, I think you have to answer. He's not.
Come to page 4.
Yes, my lord.
Tribunal's order at para 6.
Yes, my lord.
Place it.
Yes, my lord. I have carefully considered submission from both sides. It has been held in the decision relied upon by the land authorized representatives for the appellants that in case of removal of inputs as such, there is no specific provision for reversing the credit involved on input service utilized for bringing the said inputs. The relevant portion of the order of tribunal in the case of Chitrakoot Steel and Power Private Limited versus Commissioner of Central Exchange Chennai.
Yes, that decision has been followed by the tribunal.
My lord.
So you have you challenged this Chitrakoot judgment of the tribunal?
Yes, I have challenged it for years.
Have you challenged this Chitrakoot judgment?
Well, I have to,
The tribunal has followed its
Yes.
earlier judgment.
Yes, my lord.
So have you challenged that judgment?
Yes, well, I have to take the instruction. Give one
So for the appellant, seeks time to ascertain if the appellant has challenged the judgment of the tribunal in Chitrakoot Steel and Power Private Limited versus Commissioner of Central Excise 2008 10 STR 118 bracket TRI dash Chennai. At his request, list on. Second February.
Monetary limit is involved.
Since the
20,771
limit, the appeal is disposed. All right.
22. My name me kindly.
Definitely, sir.
Appearance.
None appeals dismissed.
23. May I please, Your Lordship, on behalf of Mr. K.K. Rao, may be permitted to withdraw.
Dismisses withdrawn.
24, my lord, the refund of EMD, my lord, was filed. This is not refund. Representation is there.
Or 85,000 and also, we're not interfering. No ground is made out for restoration. The SCMAPL is dismissed. Right.
25. 25 is page 10, my lord, annexure 1. The assessment order allows to pass on 30th March 2009, but it was disposed of on 14th 12 2009, my lord. After 9 months, the order was dispersed, my lord. So it is a time bar, my lord, and covered by the decision of
Notice returnable 17th April. He accepts notice. The records be produced for perusal on the next day.
26.
26.
Well, the page 13, my lord, tribunal order annexure 1 at page 13, the paragraph 6. at the last two line, but the Lawrence DCIT only found established purchase suppression and deleted the alleged sale suppression on the ground that every thing was reflected in sub account, my lord. And the Lawrence AO also accepted that it was recorded in the books of account, but without any confrontation. And the view of the Lawrence AO, my lord, kindly have a glance to the page 25, the paragraph, sixth paragraph. Further, if we'll go to the year-wise and month-wise outside purchase figure, it is found that during 2007-8, 8-9, 9-10, and 11, up to January 11, the dealer has purchased goods at rupees such and such and such, respectively. Out of the purchase made during 10-11, only in the month of January, the dealer has purchased goods in the tune of rupees such. This point proves that the dealer has arranged purchase bills pertaining the period January to 11.
Notice returnable 18th April. He accepts notice. 26 and 27.
That is 80, my lord.
27.
My lord, 80, that same period, 80, my lord. On the tax.
Same. 26, 27, same.
28.
Your Lordship. Your Lordship may kindly turn to the question of law.
MC 13 of 16 is allowed.
Your Lordship, here the interpretation is that Your Lordship may kindly turn to page 45, the tribunal's order. Whether Himani Boroplus cream is a medicine or a cosmetic, Your Lordship. That is a question of law. The Lawrence Tribunal has decided that it is a medicine, Your Lordship, but it is a cosmetic. Your Lordship has already decided in the double lal Dantmanjan, Your Lordship.
May I please, Your Lordship? That is regarding the Dant Manjan, and the Boro Plus antiseptic cream has been covered by a series of judgment. And may kindly see page 47. Rendered by Guwahati High Court and Allahabad High Court on identical issue that Boro Plus antiseptic cream is a drugs, my lords, having some medicinal value, and it cannot be termed to be cosmetics.
Let Your Lordship notice.
Say notice, he accepts notice. 19th April.
An additional question may be admitted regarding the initiation of proceeding under section 43.
It is my revision.
My lords, because of that, I pray my lords to an additional question of law may be posed.
This is his revision petition, sir. Which one? I think one question is enough. Question number 1 is enough.
Your Lordship. One and two only some judgments. 1 and 2.
No, same thing,
Your
sir.
Lordship. Your Lordship.
1 is enough. Admit the following question is framed. Just take question number 1, page 21. List on 19th April. Right.
29.
May I please know? That the state government corporation before Lordship formulatory question about the disallowance of supervision charges and TDS amount, which has been a case alerted to the unregistered dealer. The amount has been added in my turnover, but TDS has not been deducted. Next one is the supervision charges. In the next year, that has been allowed. But this year, that has not been allowed. If you Lordship see, and also the judgment of the Supreme Court guarantee declares clearly said that all charges has to be deducted, Lord. And even the Orissa sales tax are also.
Correct. That MC is allowed. Notice returnable 19th April.
Both the matter. Next one.
He accepts notice.
I'll circle.
31.
That MC is allowed.
My lord, here the tribunal order of page 21, my lord, top 8 line from top on the right hand side, on examination of the various aspects of assessment, and the tribunal held that we find that the loan and SCST has allowed flat rate of 68% deduction towards labor and service charges on whole work, which is against the principle of law. Well, what principle of law they have not mentioned? When there is non-maintenance of books of account by the dealer and inventory execution of various type of works. On the other hand, the law and STO allow deduction towards labor and service charges, considering the nature of work, which is now very just and proper. Well, the work entirely labor-oriented and the works are already mentioned in the.
What's the tax effect, sir?
Well, here the only refund issue is there also.
Your Lordship, only that is 40,000, because the assessing officers granted the refund of 1,31,360. The first appellate authority has enhanced the refund to 1,77,000. So the balance is only 40,000. So if the Lorraine Tribunal has confirmed the first assessment order, Your Lordship, that is 1,31,000. So it says 40,000.
There are no substantial questions of law arising from the impugned order of the tribunal, which affirms the order of the first appellate authority, which in turn affirms
the assessment order.
The order passed by the
partly allowed,
which is partly allowed the appeal filed by the state against the order dated 31st July 2007, passed by the Assistant Commissioner of Sales Tax, bracket ACST Koraput Range. The net effect of the impugned order was only that the refund amount payable to the present petitioner would get reduced by 40,000. The court does not consider this to be giving rise to any substantial question of law. The revision petition is accordingly dismissed.
32.
Man appears dismissed. Same next one.
34.
May I please, my lords? Lordship, may kindly turn to page 37 of the brief minutes. Lordship, got it?
Yes.
At column 3, my lord, the address of the petitioner has been given. And in the bracket, your Lordship, may kindly mark, presently being operated at Vikas Nagar, Badambadi, Cuttack, my lords. Now, this was for the period 1/4/2012 to 31/3/2014, my lords. This was the previous period, my lord. Subsequently, my lord, for the period 1/10/2015 to 36/2017, my lords, allegedly, my lords, audit was conducted and audit report was served. And I have annexed the assessment order at page 26, your Lordship may see. It's a Bhubaneswar address and an ex parte order of assessment is being passed, my lords. My very humble contention, Lord, is subject to your Lordship's kind consideration, Lords. I just need a chance that let them give me a copy of the audit report. Let me be given a chance to participate in the proceeding, Lords. Because this particular notice, Lord, even though they know that I'm operating from Cuttack, Lord, still they conduct an audit, Lords, and issue notices at the Bhubaneswar address. And the assessment order is also in the Bhubaneswar address, and it's an ex parte assessment, Lords. Your Lordship may fix the time limit, my lord, by end of February, let them complete it, my lords, because it's a very vital, my lords, forum where I have to establish my records.
Your Lordship, this is an assessment order. Your Lordship may kindly turn to Annexure 1. This is dated 15/7/2019.
Lord, my specific is... sure, I'm sorry. Even though it is stated to be 15/7, let me just... 2019, my lord, it was not served on me till 9/3/2022, my lord. That is my specific averment, my lords. When I went, my lord, that is my specific averment.
Let me call for the record. Your Lordship, 15/7, and also he has not received any notice.
Yeah.
Also, notice have been
The
served.
contention of Mr. Curry, learned counsel for the petitioner, is that although the assessment order is dated 15 July 2019, it was served upon the petitioner only on.
Lordship, it is the appealable order. It is
9/3/2022.
It is assessment order. It is appealable.
Lord,
so let him file appeal here.
Appellable, but
all factual
no, it's ex parte.
It's an ex parte
On
order,
9th
Lord.
March
So,
2022.
not to cut down, my Lord, cut down, delay, my Lord. I was only
party order.
not to cut down, delay, my Lord. I was
Mr.
only
Mishra seeks time for instructions. No, it seeks time to verify the record on the above aspect. Posts of the record we kept ready for perusal by the court on the next date.
9/3/2022. It's my averment that I've received it on 9/3/2022.
You said that.
No.
Next on 11th April.
11th.
Yes.
Oblations.
Let's see, in this case, I'm filing the counter on today.
All right. Reply we
Copy
filed
is
in 4
this
weeks.
after
Joined up next date. List on 11th April.
36. Can it be in the month of February, my lord? If
Why? I think urgent.
Lords, in item number 36, I have a limited prayer for grant of statutory interest, Lords. I am covered by the judgment of our Honorable High Court, Lords. I'm just presenting the copies of the judgment.
Yesterday, I received the copy that I need instruction in this matter. Yesterday, I received the
My
copy.
prayer is a very limited prayer. It is actually covered by my own judgment in case of PPL, Paradip Phosphates. And following the judgment of PPL, my lord, in a batch of other writ petitions, your lordships directed for payment of statutory interest, my lords. I have to come for a second round of litigation, my lords, because pursuant to the judgment, the refund was sanctioned without the statutory interest, my lords. So my limited prayer, in the absence of a stipulation in my order as regards the interest, which is at paragraph, the order of PPL, my lords, have just
same order can be passed.
Yes, my lords.
That's
I
right.
just have a limited prayer.
Yesterday, I received the copy, my lord. I have not even.
No, look at the pay. I
Prayer.
just have a limited prayer. I just have a limited prayer.
You don't have a copy to give him?
Yes, yes. I'll just hand over the copy. Sorry.
Same order, just give change this.
If your lordships could kindly see the earlier judgment of PPL, my lords, here the entire order is similar, barring the stipulation for payment of the statutory interest, my lords. The rest is all common, my lords. I'm just handing over.
No. What is in your matter? What order do you want to be passed?
My lords, a similar order as regards PPLs. Only that the statutory
Not
interest.
Bengal Energy.
My lords,
you do not want an order similar to Bengal Energy.
Yes, yes. The same order, because following my own case, in this case, in this batch of writ petitions, your lordships directed for payment of the statutory interest.
Right.
Now, my lords, I had to come for a second round of litigation in the present writ petition because I was not allowed the statutory interest. I was sanctioned the refund, but I was not allowed the statutory interest in the absence of a stipulation.
For refund, we remove refund. We just say for statutory interest.
Yes, but in my case, the stipulation for statutory interest was not there in PPL. I'll just show it to your lordships. It is the order following which these batch of writ petitions were disposed of. Lordship, this order of PPL.
No. So now you want another order for just statutory interest.
Yes, ma'am.
That's all.
That's all.
Just take this off for statutory interest.
And this is also covered by various other judgments of Gujarat High Court and other high courts also.
May I, my lord, take instruction and come back next week, my lord? Your lordship permit, because I have not even any instructions so far as yesterday I received the copy. So, lord's permit.
Right on the face.
I understand. I understand that.
It is right on the face of the order.
Appropriate application. That's all.
In accordance with law,
No, we'll say in total violation of the law.
Sorry. Date of payment, I don't have any idea, but date of payment and date of.
Can't say that in their application, they will say all that, sir.
Deeply obliged.
37.
May I please, Lordship? Lordship, petitioners are the villagers and the members of self-help group, Lordship. Lordship, opposite party illegally opened a liquor shop, Lordship.
Or the petitioner's representation. What is that?
My lord, what is happening? Let me submit one thing to your lordship. What is happening, my lords? If a shop is supposed to be opened, there is a Form 8 notice inviting public objections. These people are required to lodge their objection during the period which the Form 8 notice is.
So they don't.
They don't still after the
shop is opened.
They are filing representation. This representation has no statutory.
No, Lordship, previously we have also submitted the representation. Lordship, that is under Annexure 1.
The objection at the appropriate stage before the appropriate authority under the excise rules. Then only that, if that is not complied, you can come to court that our representation, our objection has not been taken. Your lordship may direct that if this representation has not been taken, their objection.
Where is the proof of?
There is no proof.
Proof of delivery of this representation. There is the proof of that.
Lordship, urgent to another date, I will submit that, Lordship.
No, I will.
Lordship, I have the proof, Lordship.
No. When was that notice period? When was that?
That is what. Where is the Form 8 notice?
It's too sketchy. This whole thing is very sketchy. You'll have to say when was the advertisement issued for opening
there
the
is
shop.
Nothing, no pleading is there.
Nothing.
Your lordship, may I suggest one thing to my lord? Your lordship may say that if there are any objections have been lodged by the petitioners during the period of.
Find out, sir. Let them find out. The petitioner seeks leave to withdraw the present petition with liberty to file a proper writ petition in accordance with law. You set out when the notice was issued for opening of the shop, when did you file your objection? All that you give us dates and copy of that objection. All right. This post office withdrawn with liberty. All right. 38.
Your lordship may cause these.
This correction is carried out. All right.
39.
What kind of correction? STREB instead of PREB. I know. There has been some great error.
In item 39, I have to file a limitation petition, a delay of 23 days. I am permitted to file the.
No, sir. Already 7 years are over. In the last 7 years, no steps were taken for limitation. The court does not propose to grant any further indulgence. The review petition is dismissed.
40.
My lord, no instruction.
No instruction dismissed.
41.
Some time may kindly be given. I will remove the liquor.
No more time.
For the first time, it is
all 7 years old.
My lord, for the first time, it has been.
No, not first time, second time also.
I have to file the certificate.
That you should follow up, sir. Once you file a petition, you can't go to sleep.
I will file the petition tomorrow. I will file the certificate tomorrow. Tomorrow itself file.
No.
One day time.
Tell us what the matter is about. What is the review for?
Review for the order that passed on 19/6/2015. The order is to be reviewed.
Tell us
because the petition was originally posted for filing of counter and instruction. But on that day, the petition has been dismissed. Against that order, I have come for review.
What is wrong? What is the error apparent in the face of the record?
Well, I have not been heard and the counter has not been filed in the case. It was posted for instruction.
No, who are you for, sir? Original writ petitioner.
My lord.
See the first line of the order.
My lord.
First line of the order.
Order on counsel for the petitioner and additional training counsel. Well, however, however, the petitioner has not filed any document in support of his contention, so the written is dismissed.
All right. No grounds made out for review. The review petition is dismissed. All right.
42.
None of is dismissed.
43.
43, my lord, the petitioner has been died, my lords.
All right. They stated that the applicant has died. The application is dismissed as having awaited.
Obliged.
44.
No instruction. No instructions dismissed.
45, no instruction memo.
All right. Memo taken on record, dismissed on account of no instructions.
46.
My lord, the matter is pending before the SESET, may be disposed of within 2 months.
Or
page number.
The present appeal is directed against an interlocutory order
16
of the SESTAT granting stay.
71524/13.
The main appeal, the court is therefore not inclined to interfere at this stage. However, the SESTAT is requested to dispose of the main appeal itself.
That's it.
Main appeal, that is Excise Appeal number 71439 of 2013, within a period of 6 months from the date of production of a certified copy. Paragraph: a certified copy be sent to the SESTAT by the registry forth.
47.
The impugned copy of the impugned has not been filed, my lordship. Grant 1 week time so that I can file. Your lordship, the matter is that here the tribunal's order is under challenge, my lord. There the tribunal held that the appellate authority doesn't have the power to condone the delay in filing the appeal. The demand was for 3,95,344. Beyond 60 days, doesn't have the power. Only our prayer is it is to be remanded so that by the note, your lordship a ground 3, my lord, your lordship a state.
Yes. Yeah. You see the short ground on which the SESTAT
Your lordship, the clarification received from the head of his Coast speaks that no services shall be levied or collected in respect of taxable services provided by the Indian Railways.
In filing ST Appeal number 75331 of 2014 was that the Commissioner Appeals had himself dismissed the appeal on the ground of delay. Stop. The delay was to the extent of 47 days, whereas the Commissioner Appeals could not have condoned delay beyond 30 days. Paragraph: the above order of the Commissioner Appeals was not erroneous, since indeed he was not empowered to condone delay beyond the limit of 30 days, in addition to the statutory limit of 60 days for filing an appeal before him under Section 85 of the Finance Act 1994. Consequently, no substantial question of law arises for determination of the impugned order of the SESTAT. The appeal is dismissed.
48.
3 days of delay in filing.
Tell us what the review.
3 days of delay.
Come on, merit, sir.
Not the petitioner has the petitioner filed a writ petition, petition which was dismissed by order as by this division bench on 21225. The appropriate part is that no fault in the findings of the recorded by the labor court is pointed out, and the only argument advanced before this court is that the conclusion of the labor court is wrong, as no ground made out to interfere in the impugned order. And this is the order only, not a speaking order. It was passed, my lord. The fact of the case is that the petitioner.
You're not arguing an appeal, sir. You have to find out, tell us what is the error apparent in the face of the record. This is a review petition.
My lord, in review, lordship may interfere due to important evidence.
Yes.
That I have enclosed in Annexure 6, my lord, Annexure to this appeal, my lord.
This is a review petition, sir.
It's a review petition, now. Even important evidence I have found, my lord. Ground 16 I have taken. Ordered the register of wages, Exhibit B, produced by the employer, shows wages from period 1/4/2011 to 30/4/2011. The petitioner was getting basic pay of 103 from period 1/12/2011 to 31st December 2011. He was getting 105, but the labor code calculated the wage paid only 95 man. So the labor code would have granted rupees 103 and rupees 105. Copy of the wages sheet I have enclosed as 3 and 4. The petitioner is a poor worker, my lord.
He claims he suddenly found it. Yeah. No grounds made out for review.
My lord.
All right. No grounds made out for review. The review petition is dismissed. Delay is concluded.
49.
Appeal is dismissed.
50.
No instruction.
No instructions.
51.
51, my lord. The ground number 7 and 8, para 7 and 8, we have not brought to the notice of this honorable court. The judgment passed by this honorable court under Annexure 2, my lord. And the report of informational rookie, we have not brought to notice of the court. I pray, my lord, the opposite partner 4 may accept our order under Annexure 2 and the report. This honorable court directed the opposite partner 4, my lord, petition to submit the representation, and the opposite partner 4 they considered the same. And at the time of hearing, we could not brought to the notice of the court under order Annexure 2, my lord. Similar petition has been dismissed. 4 petitions, my lord.
I know all this is over, sir. What is the only relief granted? Just come to the page 13, 27/10/2016 order. Just come to the relief.
My lord. Page 13, my lord.
Bottom.
The grievance of the petitioners.
No. Bottom, last paragraph.
In view of the aforesaid allegation that the petitioner has been affected by the activities of the opposite party number 1, we dispose the petition of the observation in case of the petitioner file a representation before the opposite party number 4, highlighting their grievances. The said opposite party will make an inquiry in presence of the petitioners and the representative of the opposite party number 1 after giving notice and take a decision in accordance with law.
What is wrong with this, sir?
Lord,
what prejudice does it cost you? Your steel authority, what prejudice is it causing you? Nothing. Just have to consider one representation.
My lord.
So no grounds made out for review. Dismissed.
52.
My lord, no instructions. No instructions. Dismissed.
53.
53, my lord, no instruction. No instruction. Dismissed.
54.
Original copies of the order has been filed with the appellate authority. So Annexure 2 and 3 mechanism.
43,000. 43,000 is the tax.
Tax amount being insignificant, the court's not declared to interfere. The question of law nevertheless is left open for decision in some other appropriate case. The petition is disposed of.
55,
36,390.
Same order, 55.
56,
None appears dismissed.
57,
My lord, petition on behalf of Mr. R.K. Raut, my lord, file is misplaced, my lord. So I propose next week, my lord.
No. The petitioner states the file has been misplaced. The petition application is dismissed on non-prosecution with liberty to the counsel for the applicant to revive it in case as and when the file is able to be traced.
58,
None appears dismissed.
59,
Same order.
60,
I filed for restoration of the retribution dismissed for default. On
Delay.
12/11/2014. On the ground that I have not solved the copy to the central government.
There is a delay of 909 days in filing this application. 999 days in filing this application. Explanation offered is neither convincing nor satisfactory. Accordingly, MC number 261 of 2017 is dismissed. Consequently, the same appeal is dismissed.
well, I am for the appeal. 61, 61,
None appears dismissed.
61. The item 61, my lords. So I will remove defects, my lords.
Copy has not been solved. Copy then.
I will solve.
You are appearing, Mr. Sahu.
69.
69. I'm so sorry. my lord.
61, none appears dismissed.
62,
May I please your lordship? Your lordships kindly see page 7. My questions of law at paragraph capital D, whether the tribunal is correct in upholding the levy of double penalty under section 935 of the OET Act, admittedly when no entry tax was due and payable at the time of assessment, my lord, pursuant to the decision of the Honorable High Court in Reliance Industries case, which has been reversed on 28/3/2017 by the Honorable Supreme Court. My lord, when the order of assessment was
You remove
passed,
the defect, sir.
my lord,
You have not served a copy. It says 5D is what defect.
I'll solve the copy, my lord. Today, my lord.
All right. Copy of the petition will be served on counsel to the state today. Second January.
63,
Your Lordship, item number 63, no defect, Your Lordship, only dispensing of the certified copy, Your Lordship.
That application is allowed.
Your Lordship, the question of law, Your Lordship has already decided at page 17. Your Lordship, the question of law, that 40-5 penalty.
So notice 19th April.
64,
Your Lordship, 64 is that purchase tax.
Anyway, none is appealing. None appears dismissed. All right.
65,
65, 2 weeks time to comply the defects, my lord. Limitation, only 2 days limitation.
All right. Defects be cured as a last chance within a week list thereafter.
66,
May it please your lordship. My lord, I'm on
Yes.
virtual mode, my lord.
Yes.
My lord, no instructions in the matter, my lord. Lordship,
All
but
right.
give me the liberty to come back, my lord.
Okay. Counsel to the petitioner seeks leave to withdraw this petition with liberty to file a fresh petition if any cause of action survives.
I'm obliged.
Disposed of his withdrawal.
I'm obliged.
67,
Your lordships may kindly come to page 5 of the revision petition. Your lordships may kindly see capital B of my questions of law, whether the tribunal is justified in upholding the order of assessment, particularly when the order of assessment is barred by limitation as prescribed under subsection 3 of section 43 of the OBAT Act.
Your Lordship, so far as the barred by limitation, Your Lordship, this assessment order has been passed pursuant to the direction of learned tribunal. So, Your Lordship, 49(2) is there. Your Lordship may kindly turn to Annexure 1. page 12. Page 12, Your Lordship, paragraph 6. In the result, the appeal is allowed and the impugned order passed by JCST hereby stands set aside. The matter is remanded to the Learned STO for assessment under section 43 of OBAT Act, keeping in view the observation made supra within 3 months from the date of receipt of this order, Your Lordship. This order has been passed on 31st January 2014 and short, Your Lordship, the assessment order, page 14, that is the 43 impugned order, Your Lordship. Your Lordship, may I turn to page 15. Second paragraph, as per the direction of Honorable Tribunal in essay number so-and-so, received and dated 18/7/2013, and finding relating to suppression of purchase, it is reasonably believed that under OBAT Act, a substantial portion of turnover of the dealer has escaped assessment and which needs examination. Hence, the assessment is reopened under section 43 of OBAT Act, issued notice in BAT 307 of under OBAT Act by the dealer tax period from 1014-2007, 31st January 2008 to appear in person to authorized so-and-so with accounts and document. Your Lordship, may kindly turn to the provision of section 49(2) of the Orissa Regulated Tax Act. Section 49(2) says, where any court or tribunal passes an order in appeal or revision to the effect that any tax assessed in central tax should have been assessed under the provision of law other than that under which it is assessed. 49(2), Your Lordship.
Yes, yes.
Where any court or tribunal passes an order in appeal or revision to the effect that any tax assessed under this act or Central Sales Tax Act should have been assessed under the provision of law other than that under which it is assessed, then in consequence of such order, or to give effect to the finding or direction contained in such order, the turnover or any part thereof as related to such assessment may be assessed or reassessed, as the case may be, to tax at any point of time within 5 years from the date of such order, notwithstanding the applicability of any period of limitation to such assessment or reassessment under this act. So, as per section 49(2), since the tribunal's order has been passed on 31st January 2014, this order is valid, Your Lordship.
My Lord, the tribunal has, the officer has not passed the order under section 49(2). Your Lordship may kindly see the order of assessment. The order of assessment has been passed on under section 43, not under section 49(2).
No, but is it pursuant to a direction order of the tribunal?
My Lord, then the order of assessment has been completed under section 49(2).
It's all right.
My Lord,
merely not mentioning the provision is neither here nor there, sir.
My Lord, your Lordship may kindly see the page 6, para capital B. The impugned order of assessment, order annexed 2 is barred by limitation as provided under subsection 3 of 43 of the OBT Act, which provides that no order of assessment shall be made.
But this has a background, sir. This case has a background. It is pursuant to an order passed by the tribunal.
Next question, my Lord. Whether the order of the tribunal is perverse and bad in law in as much as no order of assessment has been passed under section 39 or 42 of the OBT Act before issuance of notice under section 43(1). This,
Your Lordship, same page 15. Your Lordship, my Lord senior is somehow, to some aspect, is correct. Your Lordship, 8 to 9 lines below, first paragraph. The dealer has been assessed under section 42 of OBAT Act for the tax period 1/4/2017 to 31st/12/2017, undated 6/1/2009 by STO Jatni Circle, Jatni by DR number so-and-so. Your Lordship, this is the period.
And the next one.
1/4/2007. The entire period is 1/4/2007 to 31st January 2008. 1/4/2007 to 31st/12/2007. The assessment is justified so far as the 42 is concerned. 42 has been done, and for that 1 month, January month, Your Lordship, Your Lordship, 30 SL passes 39. So and so on dated is there, Your Lordship, on 3/3/2008 respectively, which has been accepted and scrutinized. Your Lordship, for this, after this observation for 1 month, I think it will be, the revenue should be protected, Your Lordship, for a month. And after this order, Your Lordship.
What's the point, sir, just for 1 month?
Question may be admitted, my Lord. Okay.
For that 1 month, the tax effect will be very little, sir.
Assessment may be remanded to verify the tax effect of 1 month. Your loss.
I should, for this sake, don't need to remand and all. You see, this is a petition by the SSC arising from an order dated 30th January 2014, passed by the Orissa Sales Tax Tribunal, dismissing the petition SSC's SA number 247-5 of 2012-13 for the period 1st April 2007 to 31st July 2007 and 1st September 2007 to 31st January 2008. Paragraph. One question urged concerns limitation, stating that the assessment should have been completed by 31st January 2013, whereas the assessment order was passed on 15th December 2014 and was therefore time barred under section 43(3) of the OVAT Act. So it has been pointed out by Mr. Mishra that the assessment order came to be passed as a result of an order passed by the tribunal earlier, and therefore the extended period of limitation under section 49(2) of the Act is available to the petitioner. So this has not been able to be disputed, and therefore the court declines to frame any question on that basis. Paragraph. The other question urged is that for a short period of 1 month, between 1st January 2008 to 31st January 2008, there was only a self-assessment under section 39 of the Act, which preceded the reopening of the assessment for the period under section 43 of the OVAT Act. And therefore, in terms of the decision of this court in Keshav Automobiles, put the citation, the reopening of the assessment is bad in law. Paragraph. It is seen that the period involved is just 1 month. Full stop. The tax effect is not likely to be substantial for this just 1 month. Full stop. Consequently, on this ground also, the court is not inclined to frame any question on this issue. The revision petition is accordingly dismissed.
68.
None appears dismissed.
69.
69, my lords, I will remove the defect by tomorrow, my lords.
Or last chance to remove the defect within a week list thereafter. Right.
70.
May it please your lords. My lord, Honorable Justice Raman.
Just before a bench of which Justice Raman is not a bench. On 4th January.
4th January.
We can actually give it
After 4th January.
On 27 January.
27
January.
71.
None appears dismissed.
72.
Lordship, kindly taken up next week, Lordship.
Defects be removed within a week list thereafter.
Lordship.
73.
Yes, in this case, yes, I have filed this interim application for clarification because why it is required, my lords. That's your lordship, kindly see paragraph 11, my lords.
They have not sought extension of time.
Yes, my lords. Because your lordship directed both of us to me, my lords, to file the accompanying documents by 28th November and to the department to pass finalize audit by 21st of December. And all the two directions, your lordship have reiterated said, paragraph 12, this will be subject to the commissioner granting reasoned extension order.
Correct.
So I waited till 28th when I was called upon by your lordship to comply with lordship's order. I did not receive any reasons for extension order.
Your lordship
So
in that order.
my client wanted to stick by advice. I also, I have no, the way I understood, I also said that because have you got, he said no, till today I have not received any extension order. So therefore, my lords, your lordship said, I complying and my friends complying on 21st, all depends upon my lordship. One line I am reading, paragraph 12, your lordship said, it is reiterated that the above direction should be subject to the commissioner granting extension of time for the issuance of a final audit report in terms of provision to section 65(4) of the OGST Act. In other words, if such extension is not granted, then even the draft audit report annexure 1 would stand automatically quashed.
Your Lordship, I may be wrong, Your Lordship, so far as the understanding is concerned. After Your Lordship's passing of the order, Your Lordship, department has filed petition, and after dismissal of that review petition, immediately commissioner has extended the limitation period, Your Lordship, and we have waited. Department, the assessing audit officer has waited. Since Your Lordship was directed to file, but the petitioner to file the submission by petitioner or not later than 28th November. Even we have waited since 28th November night at his filing. He has not filed till 28th November. And on 29th November, Your Lordship, in order to, for the principle of natural justice, Your Lordship, we have issued another notice that Honorable High Court has directed to file you some before 28.
1 minute, Mr. Mishra. Are you saying that the commissioner has granted the extension?
Your Lordship, immediately. Your Lordship.
So that's the only thing.
We have no authority to Your Lordship to.
No, just show it.
It is neither uploaded nor communicated.
No communication, Your Lordship.
How can I know?
So far as the communication, Your Lordship, what I can understand from Your Lordship's order, there is no direction to communicate the extension to him.
Application now. Now that he's extended, you can withdraw the application.
I will withdraw, but Your Lordship, now he has asked me to file reply by 6th. Your Lordship may say that I will comply by 6th.
Yeah, obviously. You say Mr. Mishra has handed over with a copy to Mr. Sahu, Lamsina Council. Copy of an office order dated 25th November 2022 of the Commissioner of Sales Tax, not State Tax. Is it State Tax?
State Tax.
State Tax.
Yes.
Granting extension of time till 21st December 2022 to complete the audit. That view of the matter, Mr. Sahu seeks leave to withdraw the present application.
To comply, annexure 4 will. Now they have issued a notice
for complying with the notice in annexure 4.
If it is ready,
has withdrawn. All right.
If it is ready by the petitioner, Your Lordship, then immediately by tomorrow, because the officer has to get some more time, Your Lordship, because time is
anyways
21st.
So I will comply your notice. Now, 6th is the date you have given. I will comply.
Your Lordship,
the correction is carried out as pointed out by the office. The order be uploaded. The corrected order be uploaded afresh. Right.
Minus
72. Sorry. 74.
That's over, sir. We just not dictated. I've just not dictated in 74. No. Correction, sir. 73 is over. With the long order, Mr. Sahu is withdrawn. In 74, correction be carried out as pointed out by the registry. The corrected order be uploaded.
75.
75 may I please, Your Lordship.
74. So 74, some typographical error has been pointed out.
I am on 75, my lord.
Yes.
The villagers are before Your Lordship in PIL, nature of PIL, my lord.
There are 2 defects pointed out, sir.
I will remove by next week, my
All right. Defects we removed within a week. List that out.
Oblige.
76.
Item 76, I'm in VC, my lord. There are some minor defects. If it can be ignored, then I can place the matter, my lord.
You remove the defect, sir.
Then can it come?
What is the defect? What is the defect?
My associate was saying some minor defect is there, my lord. I'm not sure about.
No, minor means he has not given any representation before because it is a PI.
Non-compliance of rules.
Non-compliance. That is a mandatory.
No, this is not
Without that, you cannot maintain a repetition.
No, this is not a PIL, my lord. I'm not filed it as a PIL, my lord.
This is not a PIL.
No, my lord. Absolutely not.
Then why is it before this bench?
No, it is an excise matter.
It's excise matter.
They are all public, representing the public as a. Anyway, if that is so, then other defects are there.
Here, what has happened in a residential commercial complex, an on shop has been opened by virtue of a license granted by the excise commissioner and the collector of Khordha, my lord. We are the residents of the same building. On the ground floor, the bar has been opened, and we are staying in the second floor onwards to the sixth floor. And not only that, within 500-meter radius, there are schools, worship to a public school, my lord, which is in direct violation of the Orissa Excise Manual, my lord.
My lord, this is the same type of case your lordship has dismissed just before.
The objections were, did you file objections?
No
objection.
objection. That is the.
Then how can you come now, sir?
This is not maintainable. That your lordship has already held it.
Let me
that they have not lodged any objection in pursuance to the Form 8 notice.
Correct.
That is mandatory. Now, after the shop is running for last more than 3 months, he is making a petition directly before this honorable court that this is not.
No, my
missed the boss.
My specific averment I've taken in the grounds, my lord, because we were never ever, because we were the residents there, and the forms were never circulated in our building.
No. That is a public notice inviting objection. It was, and pursuant to it, your lordship, I submit before your lordship, many objections were filed, not the petitioners, and those are dealt with in accordance with law.
Yeah, but can
the shop is running for last 3-4 months.
No, I filed the writ in October, my lord. On 19th of October, the writ was filed immediately after the notification was issued. So
the notification is preceded by a notice inviting objections. After all objections are considered, then only the notification is issued.
Objection is in the preliminary stage itself.
What I'm trying
by
to
the excise is superintendent.
What I'm trying to say in this case, we were not ever, because in our building that Form 40 was never circulated, my lord.
How do we can't, it will be a factually disputed question, sir.
Can I just make one small prayer, my lord? Let my State Council say that this shop has been is not within that 500-meter radius, my lord. Then I don't have. This is my simple prayer, my lord, because the DAV
that is not. That has already been dealt with. Must have been dealt with by the file. And after considering all the objections, this license was granted to the vendor. So these points which you are now raising, you should have raised before the.
No. But Mr. Acharya, tell us this.
Yes, my lord.
So clearly, prior to this petition, you never formally lodged any objection with the department, correct?
No, my lord, absolutely.
Then
at the appropriate stage.
Because my instructions, sir, and the government they have taken the rate.
So without that public notice, there's no question of issuing a license for a non-shop.
And your lordship must be in this case twice public notice was issued, twice. And there was a case before this honorable court, and the matter was remanded. Ultimately, government granted the license. So, if he has some grievance, he should have lodged the complaint before the appropriate authority at the appropriate stage. That is before the collector. Collector is inviting objection.
But there is also a provision that the form has to be circulated in the local area.
Yes, we have. How can you say that it has not been circulated? It was duly circulated, that is, and many objections were filed, and some objectors also filed writ petition before this honorable court. Those are dealt with. Everything has been complied. Now another set, your lordship may see, this another set of petitioners are coming, that after this shop is running for last more than 4-5 months, they are saying that
the notification was issued in September only, 19th.
3 months. 3 months.
3 months. I'm sorry, 3 months.
Before that. No. A simple submission I'm making, my lord. Let's say that this shop is within more than 500-meter radius from the DAV public school and the play schools in and around that area, and the Sai Baba temple, my lord. Then I don't have a case, because this is of a serious nature. We are staying in that same building, and in a residential building, a shop has been opened, my lord, a bar.
Your lordship knows in Bhubaneswar, everywhere there is residential building, and we have to give license to the on-shop and off-shops. And so far as the school matter is concerned, that has been dealt with by the collector while issuing the license. That has already been dealt with. And these are all afterthought. They have never approached the appropriate authority at the relevant time. And
but
when the objection was invited...
But 1 minute. Is it really, because he seems to say that this is exactly opposite the school?
No.
Less than 300
It is at a distance, and 5-star restaurant having an on-shop. It's not just regular on-shop.
It has a bar. Are you not serving liquor? That is my question.
The question, and that is a commercial space. I have taken it on lease, and this is not a residential.
It's a residential.
I also filed my objection counter to this petition.
Because it is a residential cum commercial
It
building.
is the back portion is residential, front portion is commercial. I have taken 25,000 square feet. I've taken on lease, and running the restaurant since last more than 4-5 years. Now only I got the objections, and there were objections. It has been considered. 2-stage objections were made, and he never objected there. But all these things has been considered. And when I approached this honorable court, state government granted the license and notified.
But nowhere they are coming out and saying that this shop, this bar cum restaurant is beyond 500 meters from the school and the place of worship, my lord. That they are totally silent.
That has already been dealt with during the objection stage. This particular factor has been dealt with.
I am on this particular bar and the restaurant, my lord.
Yes, this particular bar and restaurant. You are now coming forward representing a separate set of objections.
When were the dates of that? Which objections were in your affidavit? You're not mentioning what the objections.
No, I have not mentioned because preliminary objection I filed.
I think you just put on affidavit. That's
yes.
Yes.
All right. Mr. D.K. Mahathi, learned AGA states that he will place an affidavit, copy of the notice, public notice issued, the objections received, and the consideration of the objections.
My lord, I will
prior to the grant of
counter
license for the on shop in question. Yes.
I filed a detailed account reference.
The affidavit will be filed within 4 weeks. Rejoinder thereto, if any, be filed before the next date. February 6th.
Obliged, my lord.
My name may be indicated. It is not.
Yes. Mr. Pal's name be Mr. Avijit Pal, counsel for the opposite party number 6.
Great.
77.
Order of the revisional authority at page 22, my lord. Exercising power under section 79(1), penalty has been imposed, my lord. That is under challenge. And that was followed by fresh demand notice.
This OTAPL is not maintainable, your lordship, since this is appealable to the commissioner. As per section 79(7), your lordship. Section 7, your lordship, may kindly turn to section 79(7) of the Odisha Value-Added Tax Act. This order has been passed by additional commissioner. 79(7).
So from additional commissioner to commissioner.
Commissioner, if commissioner,
for the appellant seeks leave to withdraw the present appeal with liberty to file a revision petition under section 79(7) of the Orissa Sales Tax Act.
Appeal, my lord.
Orissa Value Added Tax Act, 2004.
This is appeal, my lord.
No, this is an appeal. What you have to file is a revision, I think.
No, that is also appeal, my lord.
Appeal. Achha, yes. With liberty to file an appeal before the commissioner under 79(7) of the OVAT Act.
79(7) small b.
Disposed of is withdrawn with liberty is prayed for. If such appeal is filed not later than 9th January 2023, accompanied by an application for continuation of delay, explaining the delay on account of the pendency of the present appeal, shall be considered in accordance with law by the commissioner. The court clarifies it is not expressed in view in the matter. You have filed any originals here? Have you filed any original?
Yes. This is so much revision.
Original order have you filed?
I have to check, my lord.
All right. Originals be subject to being substituted by its photocopies thereof.
78.
May I please, Your Lordship? My lord, in this case, there are two revision applications. The question of law is whether the tribunal is correct in disallowing ITC on purchase of LPG cylinders. The first matter and two other issues are there. Whether charging of interest and penalty on the deferred payment of administrative tax, and third is charging of interest penalty on the wrongly availed ITC. And with regard to the ITC on purchase of LPG cylinders, Lordship may kindly turn to the assessment order, Your Lordship. Annexure 1, page, Your Lordship may turn to page 27.
Yes.
the observation 1, it pertains to admissibility of ITC on packaging materials. The dealer company during so-and-so, relating to VAT paid on purchase of empty cylinders from registered manufacturer of Orissa for use in packing of LPG for sale. But on verification of so-and-so, now he has dealt with, and now at page 28, after we produce the documents, he has said that on production of supporting documentary evidence, the allegation made in AVR carries no force. Now he has negatived this is an audit assessment. So he has negatived the observation made in the audit visit report. Now, after that, what he is saying is there is no allegation spelled out in AVR as regards admissibility of ITC on purchase of empty LPG cylinders from registered manufacturers of Odisha except to disavow ITC so-and-so. A reference to audit assessment concluded in for the previous period, in case of dealer, instant dealer reveals that so-and-so, so-and-so. Hence, thereafter, to have an uniform approach in the matter, it is felt necessary to analyze such transaction and to order to evaluate admissibility. Now, what he has done in this specific case is he has transgressed itself from the audit report and has now dealt some issue which was not part of the audit.
We just frame the questions, sir. Admit the following questions are framed.
Page 14.
I think 1 is enough, sir.
Other 2 aspects are there, my lord. Regarding the
interest and penalty. So 1 and 5.
1, 5, and another is interest on admissible wrongly availed ITC.
No, that is 5.
That is not in this first matter.
First.
In STREV 27 and 28, I think only 1 and 5.
Lordship, can it be called on tomorrow? I can give fresh question of law, my lord. That is somehow it has missed.
Oh, then you have to file an amendment application.
Lordship, I will do that.
All right. Counsel for the petitioner states that he would like to file an amendment application to urge some additional questions of law for consideration. At his request list on 16 January. Then this interim order dated 21st December 2016. You've already paid that amount?
Part of it has been paid in first matter, part of it has been paid.
No, you were asked to pay 20%, that you've paid.
No, let that be paid.
In that IA number, miscase number, sorry. 55 2016, you see counsel to the petitioner states that the condition imposed by the interim order dated 21st December 2016 has been complied with. They said in that view of the matter, they said interim order is made absolute during the pendency of the present revision petition. The application is disposed. In each of them, it will be a different thing.
In the second matter, we have paid the entire amount.
I see. Right.
79.
May I please, Justice? In this case, this London State Council has been directed to submit, take the instruction regarding the compliance of Annexure 1 matter. This is the second round of litigation. In the first round, this Honorable Court directed the collector opposite to take a decision. And under Annexure, the London collector took the decision. And that has not been complied till now. And this spring water has been blocked by constructing chamber. And in a remote tribal area, Kasipur matter. And the petitioner has not get the flow of spring water matter.
Yes, we had filed a counter affidavit.
No. On 17th August 2022, you'd been asked to take instructions on drinking water being available in 2 villages.
In our counter affidavit, it's clear that drinking water.
So what's the date of your counter affidavit?
That was prior to
So don't, are you saying that you will not comply with this order?
No, minutes.
Who's the collector or whoever it is? We'll ask him to remain present.
Please,
If this is going to be the attitude that you don't have to obey the orders of this court, we'll ask the collector to remain present.
Give me a week's time, Millards. I'll file a detailed affidavit replying to.
A last opportunity is granted to the state to comply with the order dated 17th August 2022 by filing an affidavit before the next date. This on 13th February.
Bless you.
My lords, today they have supplied me with a status report for that they have made some joint verification. My lords, may I see the status report?
I may pardon, on behalf of Mr. UC Mohanty, getting one urgent telephone call from the school of his son. He has gone. Kindly take it after lunch, my lord.
Okay, after lunch. All right.
My lord, after lunch, first
You're not available.
No, my lords, I'll be there, but kindly be taken as first matter.
I can't say all that, sir. We'll take it up after lunch.
My lords, next week, any date.
Where is the status report? Have you placed it?
My lord, the status report, they have just submitted
has it,
wrong data to the court, my lord.
File, man.
That bridge, they have little
The
bridge
status
completed,
report
but
said
that
to be
bridge has
filed by the-
collapsed, my lords.
NHAI we placed on record. Consider the NHAI stated in some personal difficulty today. List on. Seventh February.
7th?
February.
My lords, my lords, 7th February will be too late, my lords.
No, it won't.
My lords, next week, any date, my lord, on the last occasion, they didn't appear.
It's all
I
right.
just only got a date.
It's all right.
My lord, so many dates are, nothing is happening, my lords.
All right. Yes.
My lord, they have given in the
81.
report that the bridge is complete, my lord, the bridge has collapsed. Two
All right.
persons are injured.
All right. All right.
My lord, taken on January.
Let it be, sir. If there's anything urgent, you file an application. Yes.
81.
Public interest litigation regarding operation of mines by opposite party number 8, my lord. Here,
I beg to appear for R8, fellows. I beg to appear for R8.
Yes.
yes, there, my lord, without conducting a proper public hearing, they obstructed the people who are going to be affected, my lord. On the way, I have filed the photographs. I have also got the video clips. They obstructed the people who are going to be affected, and by means of some henchmen of the company, the administration has passed an order in support of building the mines, my lord. Earlier, by the Annexure 1, the central government has categorically stated that without having environmental clearance, my lord, they have operated illegally, and they need to get the environmental clearance. For that, public hearing was necessity, my lord. Now, in the region, I have filed affidavits of 582 persons, my lord. Some in joint form of affidavits. They all stated how they have been prevented, how they are going to be affected, and the scheduled time that was fixed for public hearing was 10 a.m. The earlier occasion, 2 months before, my lord, similarly, they wanted to have a public hearing. The time was fixed to 11 a.m. and before people could reach at the spot, my lord, it was held. When the people registered, my lord, they adjourned the public hearing to some other date, my lord. It was cancelled. And the second time, instead of 11 a.m., my lord, they put it on 10 a.m. so that people, with the purpose that people can't reach the spot, my lord. And here 44 villages are going to be affected, my lord. And the hearing was not properly conducted. Neither the people who were affected could participate in the hearing. 21 of the leaders, community leaders, they were arrested prior to the public hearing. And the some of the henchmen and gundas, they visited the village before the date of public hearing, and they have made caution to the people not to say anything about the company. All this is the background of the case, my lord. The central government has filed a counter affidavit, my lord, stating the provisions under which the public hearing is necessary, and they have issued a letter that is Annexure 1 of the writ petition. They have admitted postulating the position of law only. They have not stated anything about the facts of the case or the issue involved before it, my lord.
No, what about the state government?
Yes, we have filed our counter affidavit. Your lordship may kindly see, giving details of the public hearing and stage by stage how we conducted the public hearing in a legal and proper manner, and all these steps have been taken for fair and transparent compliance of the provisions of law, and all the documents I have annexed. And now my learned friend is making a submission which is more or less a factual controversy. He is saying that we have not done anything, but we are filing documents to show, your lordship, that...
No, 1 minute. Come to para 14 of your affidavit.
Sir. Para 14.
1-4. Page 233.
Lord, there is no para 14. Your lordship is holding the affidavit of Sujit Kumar Misra, assistant college.
No. This is Santosh Kumar working as State Pollution Control Board.
That is State Pollution Control Board. That is pollution control.
Just come to para 14 of that.
Yes, para 14, I have filed that counter pollution control. Then OP number 1 board has no knowledge about the prevention of large tribal mass from reaching the venue by raising barricades 3 kilometers from the venue, arrest of local leaders and youth, and threats by the police prior to knowledge as alleged by the petitioner. It is for the district administration to take care of law and order problem. On the first occasion, there was a public hearing could not be conducted because of some untoward incident created in the venue, and it was cancelled. This is the second time public hearing was conducted, and his allegation is that some persons were prevented from attending the second time public hearing. District administration. That is the allegation.
Actually, your reply, Mr. Mohanty,
yes,
now come to your reply.
Yes, ma'am.
Para 8 onwards.
Para 8.
This is just a blank denial, right? Nobody was prevented to participate. This is absolutely not a fact. 1 and 2. This is not specific. You have your videos. You have the videos.
Yes, ma'am.
To show they were being prevented.
Yes. I have filed already. Some photographs are there.
Where is that? Where is that?
And this is the pen drive.
No. Are these on record? Does he have copies of this?
Yes. Good. I have, from those photographs, I have got photocopies, and this in the rejoinder of my petition. I have given some of the photographs in the rejoinder itself. The photocopies. And this is the pen drive. From 3 kilometers before the spot, they have made checkpoints, restricted the movement of the people who has to travel from 44 villages, 4 panchayats. They could not reach, my lord. And in the winter, my lord, at 10 a.m., my lord, it's too early, my lord. It was deliberately made so that people can't reach.
Can you play the video? And share it so that senior counsel can.
Dr. Singh wants to say something.
There are several files there. So he wants to which file to play. I think VID, there are VID. This
Perhaps this one, your lordship.
Dr. Singhvi, are you able to view the videos?
No, Malas, I'm not able to view the videos.
No, we'll just share it with you.
We are also not.
Yeah, share. Have you seen, Mr. Mohanty, has anyone viewed these videos? See, these photographs and videos, he says he's already produced it. You've given him a copy of this full set of videos.
Not the photos.
Photographs are next. Photographs are enclosed to the rejoinder affidavit, but this video, for the first time, my lord, fact is that
the next video you can play in some other video.
This is the video updated. That is also not visible because on the first occasion there was some reason.
Second occasion also.
No, second occasion it was smoothly conducted.
It's all right. I think somebody needs to file an affidavit after viewing these videos and these photographs.
Okay. Any government office.
Yeah, because normally we don't get this kind of material from any petitioner. They normally make an allegation. They don't back it up. But here there are photographs, there are videographs. Dr. Singhvi, have you watched these earlier?
I have watched them just now. Can I just take 5 minutes? I mean, I understand what my lord is saying. Necessarily, one of the lordship will have it on another date.
See, the other way to do it, Dr. Singhvi, is just to cut the whole thing short because this happened more than a year ago.
What are you saying? Have another one.
We can have a time bound. Dr. Singhvi could finish the entire exercise in 1 month. Just 1 month.
We don't stand on ego. I'm sorry to cut your lordship short, Balas. I believe in this. I'm trying to get instructions that we will be on ego and we'll keep on arguing before your lordship.
Correct.
Just give me 2 minutes, Balas. There is a lot of course. I'm not going to take time. It is there. It is suggested to your lordships, but Balas, I am told, and I'm not standing on that formality. I am told that Balas, people were there. We have got from my affidavit, page 168 to 78, all the villagers who attended and spoke their signatures. We have got 165 to 167 of those who spoke, and 102 onwards, we have contemporaneous news reports. Give me just 2 minutes for just a solution. The nature of what is not a forest land is indicated in the EC itself at page 101, which says it's a wasteland, no forest land involved, etc., etc., and no ecological sensitive area, core zone, no displacement. Now, Malads, there are videos with the state also. In fact, I have been telling my learned friends that they've been banging their head to show those, but as your lordship knows, the affidavit of the ADM itself craves liberty to refer to videos, but they never produce it, and the delay is on me. Let me tell you my predicament, and then, Malads, possibly with great respect, because I think I should bow down to what my lord is saying. My predicament is that my EC being under renewal and not being granted by the interim order here has led to the other writ which is before your lordships today. My mining lease also cancelled because the lordship knows if I don't have an operable mining lease without an EC, then the mining lease gets cancelled. Now it is true that the other writ, the impugned order, though passed after your lordship stay, does not refer to your lordship stay. But it is very clear that that is a non-starter till I get the EC. So I would suggest that your lordship may put very clear conditions and some police bandobast, because in this case, give me a minute only more, 2 minutes more.
Yes.
What has happened is, right, or I'm not blaming, there were two groups, pro-development, anti-development, I'm not getting into that. But at 128 to 30, there is a clash between persons recorded in a kind of a 145 or a breach of peace situation. Now, I don't want that to, let bygones be bygones. I don't want the future, your lordship's bona fide attempt to solve it next time to lead to the same thing, and I keep suffering because of delay. So your lordship may make it clear 3 things, subject to my lord's kind discretion. 1, that there would be clear bandobast to allow those people who, because there is a large group there who believe this is development. Right. Now they may be threatened, stopped, etc. Equally, those who are opposing are welcome to come there. Number 2, can we have an observer? You can have an observer. That's clear, na? Yeah. Number 2 is the best is your lordship has a really genuinely impartial observer who can kind of record or note down whatever your lordship feels appropriate.
Correct.
Let us just see, how would I be interested in obstructing? I mean, I am the biggest sufferer. There is no question. There may be some local problem. There may be some local sentiment. But I really want to not come back and again have a fight on facts before the court. So let the observer video record in court and let the process be completed by December end, so that we come back before lordships in January.
All right. We don't have a copy of the rejoinder, my lord.
One thing is important, I'm sorry. This has to be wholly without prejudice. We have taken very strong objections.
No, naturally. It's without prejudice to your rights and contentions. We just want the procedure to be properly followed.
It is not even coming from the court as an order, because your lordship's order suggests a view. It is because we are all saying to save time.
That's right.
Otherwise, your lordship taking a view on the merits will be used here and there.
No, certainly not. So, Mr. Jena, I don't think you can have an objection if a proper procedure is followed.
No, I don't have an objection.
Nobody can have an objection.
But kindly don't indicate.
So only the collector, you'll have to ask the collector.
Kindly, I'm sorry.
To make sure that the proper arrangements are made.
That your lordship has done in case of JSW recently in Paradip. And as directed by this honorable court, the public hearing was conducted. And
because we are back in winter now, so let the hearing begin at 11 o'clock or 11:30, like he's suggesting.
Your lordship can fix the guidelines, and that they will simply follow it.
One thing,
but if your lordship is going to take a decision that again public hearing will be conducted, then all procedures have to be followed.
Correct. Correct.
And it will take some time because notice period is there and 30 days.
No. There's no question of notice now. We're only on the hearing. See, they have themselves filed the whole series of affidavits, so they're aware of it now.
No, that is okay. But your lordship, for public hearing, 30 days notice is mandatory. If the persons who have filed affidavit, tomorrow some other persons will come that we have not been noticed. There was no. So we have to follow that. That is my responsibility.
All right.
Because that procedure has to be followed. Irrespective of the fact that some persons appearing through my learned friend, they are saying that we are ready to appear. Some persons may not have any knowledge that another hearing is going to be placed by order of the honorable court.
All right. In which case, Dr. Singhvi, we can have it done by 15 January. We'll complete it because a 30-day period, even if they issue a notice, public notice by Monday, which is 5th, and the 30 days will end on 5th January or whatever that is, let the hearing be concluded by 15th.
So therefore, your lordship may make it very clear on the timeline because we are.
No, certainly. And we'll keep the petition pending.
Yes.
So that we monitor that our directions have been complied with.
Yes. One important thing.
Yes.
Your lordship, in the course of dictation, willy-nilly, it should not be that your lordship.
No, you're there, Dr. Singhvi, and I think we'll start the dictation. We'll start the dictation after lunch.
I am nobody to interrupt your lordship, but I am saying.
No. I'm serious. We'll start the dictation at 2 o'clock so that you're also there. I mean, all your associate, whoever is there.
No, I'm just saying only one thing. It is not that your lordship is saying anything on the.
No, we are saying.
Having a re-hearing because of the merits being bad in the.
Yeah, no. We will begin by saying without commenting on the merits of either of the contentions of any of the parties. All right.
And the first hearing was not bad. I don't want that to come impliedly, because we are strongly saying that the first hearing was all right.
No, we'll say with a view to obviate any, any whatever doubts that parties may have as regards the first. This is the course adopted. All right.
And another small submission, my lord. The public hearing is to be conducted by SPCB, not by the state. State government.
That's right.
is to
They're
provide
here.
that.
They're very
Direction
much
is issued to them.
Yeah.
That's all. And state government will provide
Facilitate. Yeah.
law and order.
So that there's no law and order.
Yes.
Right. We'll come back at 2:00 and
yes.
81.
What happened? There he is. All right.
Well, if I have to take your Lordship leave, my learned friends are here. But
All right.
We must say, in a lighter vein, that 40 years of habit at least we are violating your Lordship's diktat on the top of the cause list. I saw it for the first time. Diktat cannot take away, in one sentence, it can't take away 40 years of habit.
I don't stop trying though. All right. On 8 February 2022, the following order was passed in the present petition. Paragraph. Thereafter, affidavits have been exchanged by the parties. While it is a stand of the state government as well as the opposite party number 6 company that the public hearings conducted by the SPCB were in due compliance with all the prescribed procedures. The petitioners have, along with their rejoinder, placed both photographs and videographs in support of their contention that they were not. Full stop. Paragraph. Without entering into any determination, exercise of determination, without entering into an exercise of determining which of these versions is correct, and with a view to obviating any doubts on the requirement of the procedures having to be followed as prescribed by law, all parties have agreed that the exercise of the conduct of hearings, public hearings, by the SPCB can be repeated in a time-bound manner. Full stop. Paragraph. Mr. D.K. Mohanty, learned additional government advocate, has pointed out that such an exercise would require a fresh public notice of the hearing to be issued, with 30 days time being given to parties to file their objections, and for a hearing to be scheduled after the expiry of those 30 days. Full stop. He points out how the hearings have to be conducted by the SPCB with logistical support, including arrangements for law and order control, being the responsibility of the state authorities.
That is the responsibility of the state authority.
The public hearing is to be conducted on the supervision and will be presided over by the collector or his representative.
Whatever is there, sir. Whatever is there.
Preside over.
Paragraph. Dr. Singhvi, learned senior counsel appearing for opposite party number 6.
8, my lord, not 6. 8.
Sorry, opposite party number 8 has clarified that their consent to this exercise is without prejudice to their rights and contentions. Full stop. He has further suggested that there could be neutral observers for the entire exercise. Full stop. Paragraph. In view of the, accordingly, the following directions are issued by this court. 1. Fresh notice of public hearing on the for public hearing for the purposes of grant of environment clearance for the bauxite mining project of opposite party number 8 will be issued afresh preferably not later than 7th
By
December-
SPCB, my lord, by SPCB.
by the SPCB not later than 7th December
Yes.
2022, giving 30 days clear time for objections to be filed to
There will be adequate circulation of this, that your lordship can also.
there would be adequate publicity of the said notice both in the print and electronic media, and all statutory requirements attendant on such public notice for the purposes of easy clearance will be complied with. 3, on the conclusion of the 30-day period, the public notice will indicate the time schedule,
Date,
regarding
time
the
and
last
venue.
date for receipt of objections and the date or dates of public hearing.
Date, time, and venue.
Yeah, dates, time, and venue of the public hearing. Full stop. Given that this is the winter period in the area in question, the commencement of the public hearing should not be earlier than 11 a.m.
Yes.
3, the entire public hearing will be videographed.
Yes, that is the procedure.
That,
Right.
and the
Your lord-
collector will preside over that public hearing.
Your lordship may mention that it's in the same venue.
Now, venue,
So you
they
fix
will
the venue,
decide.
sir. We don't have to
You will
mention.
decide.
Whether we mention or not, we are leaving it to you.
Yes.
Huh. So you fix the venue, you fix the time, schedule, everything. Huh. This for the neutral observer,
District judge.
one could be the district judge, the other could be an advocate, or always there is an issue.
No, we have
One is
experienced.
there is Mr.
That
Shiva.
we have experienced, so no advocate should be sent. That is- your lordship can remember that event. So no,
The district judge.
Yes, man.
Or
Or DLS secretary, being assisted by DLS secretary.
okay.
No.
The district judge Koraput and the secretary, District Legal Services Authority, Koraput, will remain present as observers. Dr. Singhvi is here or?
No, his junior is there.
Junior.
Associate is there.
That is okay for us, my lord.
All right. Will be the neutral observers for the event.
Whereas I'm here.
All right. The entire exercise be completed positively by 15th January 2023. The collector's request to, then you come out of that, no subparas. You say the collector will, the SPCB will
Yes.
place the report along with the videographs.
Minutes of the meeting, public hearing,
And the minutes of the proceedings, along with an affidavit to be filed before the next date with advance copies to all the other parties.
One prayer, my lord. No unnecessary hindrance in the smooth passage of the people.
Yeah. You say it will be the responsibility of the state authorities,
The district administration.
and in particular the district administration, to ensure smooth and safe passage of all persons who wish to participate in the hearing, and for the maintenance of law and order throughout the hearings. Right.
By this process, the environment clearance process notification 6 will be complied with.
Sorry, sir.
My lord, by this process, The environment clearance process notification 2006 will be complied with.
We've said that all statutory compliance,
that is in
whatever has to be
portions of
followed
that
will be
only.
followed.
In portions of that notification, your lordship is directing all these things.
Well, sir, there is a point there. It should not be said that though it is all done bona fide under your lordship's order, somebody says that something has not been done, etc. Because the whole point is that your lordship is doing it under a court order which is after 1 year of the whole time being known to everyone. Now, if they start again arguing that the process itself is wrong, I can understand the law and order part and not heard.
This is in kind of a consent order. We recorded right in the beginning.
That's what I'm saying.
All parties have agreed to this.
Yes, so therefore, let that be in some form clear, Malus, because that otherwise on this part there should be no challenge. Malus. This is a consent order.
This is the consent of petitioner also. Petitioner has also
consented. That's what everybody is consented, sir. There'll be no issue on that.
Kindly record that. Yes.
It is clearly understood that all parties have agreed to the above procedure.
Lordship.
All right. List on. Shall we have it on 30th January at 2 p.m.?
Yes, Malus. 30th January. Very well. Yes. I'm grateful.
At 2 p.m.
I'm grateful.
All right.
So there is one thing I have to trouble your lordships about.
Yes.
In the same item 81, the same time, without any more ado, Malus, your lordship may issue notice in a related writ, which is tagged along with this by a lordship division bench order, for the simple reason that my mining lease, as I told your lordship in the opening, has been largely on the lack of an EC. That's 28704 of 22.
All right. In 81, in 28704 of 2022 notice, Mr. Paddy accepts notice for opposite parties numbers 1. Mr. Paddy?
Yes, ma'am. Yes, 1 and
4.
1 and 4, yes.
And Mr. DK Manti for 2 and 3.
2 and 3.
All right. Replies be filed within 4 weeks or 5 weeks and rejoined before the next date. Again on 30th January.
My lord, one clarification. These materials of public hearing, minutes and videography, etc., all are sent to the ministry.
You have to send whatever you have to send. We are not stopping you from doing that.
That is after 30th January. After the same is.
Copy of the order. Copy of the order maybe.
Yes, immediately. We'll upload it by the evening. You'll get it all. Urgent copy we issued.
My lord, actually, of the court, that area is very vulnerable. So, no advocate, I don't advise any lawyers to go there. That is very, not a.
All right.
They think so. It's not like that.
Okay.
Very deeply obliged. Very deeply obliged.
All right.
May I preliminary lordship first matter along with me, number 6 of India. Mr. Raigur is appearing with me. Let's me reflect it.
All right. Mr. Raigur. All right. Right.
Also second matter.
Yes. No, we'll first exhaust the list.
Item 82.
My lord, in this case, I have received the counter. So 1 week may be allowed to file the rejoinder.
Rejoinder will be filed for the next date. 20th April. 20 April.
20. 83.
Please, your lordship. The preceding occasion, that is on 26/4/2022, the department required to file an affidavit regarding the nature of a service of or notices service of the order, because total demand was raised 54,83,297 at page 9, my lord. That is annexure 1. Regarding to notices or service of orders, they have not yet confirmed. Now they have taken in the subsequent order 26/8/2022, press sought adjournment to file a reply. What reply they have filed regarding the nature of a demand? Exactly service of order till today, I do not have any notice or knowledge about that. Let them file to whom they have sought the order passed by the department.
1 minute, the 6359, were you asking for recall of an order dated 6th May 22? I'm not able to understand that. Anyway, that's infructuous now, I think.
No, it's wrong.
This 6359 of 2022, this application is disposed of as having become infructuous. No reply has been filed till date.
Your Lordship, for which time actually the details are here. And here, let's see, for which time may be granted to file reply. Also, the petitioner is to file an application. Your Lordship may kindly look into the last order, 29th September. Why, Your Lordship? Because that 54 lakhs demand subsequently has been reduced by to 49 lakhs. Reduced, Your Lordship, some demand has been struck down, and by order dated 26th August, Your Lordship has already observed that demand has been reduced to 49 lakhs.
Yes.
Your Lordship, by these, the petitioner, last occasion, the petitioner wanted to file an application for modification for amendment of the writ petition, Your Lordship. For that reason, I am waiting for that application in order to file the counter.
My Lord, my first grievance is whether orders have been passed. If the orders were passed, to whom they have served, raising the total demand of rupees 54 lakhs or they now reduced to 49. I should know the exact demand and to whom they have served.
Everything is here. Everything is here.
Let me
hear meaning.
Your Lordship, in a chart.
Unless you give it to him, how will he know?
Your Lordship.
You say Mr. Mishra states that.
Also, I have given a copy.
You have to file an affidavit, sir.
I'll file.
Mr. Mishra states that the department will file an affidavit placing on record the revised demand of rupees 49,13,192. Stop. Mr. Panda states that on receipt of such affidavit, within a week, you say.
Within a week.
Mr. Panda states that within a week thereafter, he will file an appropriate application for amending the writ petition. Paragraph. Parawise replies be filed. Anyway, all right, amending the writ petition. We'll just give a date and it will come up earlier than that. You say list on. First March 2023, the interim order to cut.
Service of orders.
85.
This 85 and 86 are connected matters, my lords. It's my mistake, my lord. I misplaced the counter so far as 85 is concerned.
Okay.
So I'll file a rejoinder in this. 86, I've already filed a rejoinder.
All right.
And my second humble prayer, my lord, would be this matter may be taken up on the 15th. My lord, the urgency is that this relates to the refund of the inverted tax duty structure, my lord, on electrical vehicles, my lords. So subject to your lordship's kind convenience, if it may be taken up on the 15th. In the meanwhile, I'll file a rejoinder in the first case, my lords.
All right. Both these matters, you say at the request of Mr. Curry, list on 15th December. Meanwhile, rejoinder be filed in writ petition civil 21008 of 2022.
All right. 85, 86, same, my lords.
Yeah, same. One order in both.
It's by item 87.
87.
More time may be required for filing of counter.
Reply be filed within 8 weeks, rejoinder before the next date. Interim order to continue.
No, there's no interim order.
No interim order. List on.
It's a C form.
List on 27th March.
It's a C form issue, my lord. Sometimes in February, my lords. Because here, my lord, what has happened? The business has already been completed. Due to technical lapses, my lord, the the CST Act was given on a much later date. The transactions were earlier to that, my lords. So now the oil companies are, my lord, pressing hard, my lord, for the C forms.
Second March.
Any date in February?
February is all heavy boards now. Let it be 2nd March.
Obliged.
Right.
88.
May it please, my lords. 88, 89, 90. Even though they relate to 148A, but these do not require any much duration. As because ex facie it is illegal on the face of it. Last time your lordship removed it from the category and it was fixed to this day.
That is beyond 1 month after the...
Yes, that is Annexure 1. This is not regarding this 148AD that Ansul Jain My lords, yesterday I was surprised to tell your lordship, after Ansul Jain, the judge, the presiding judge, in that case, in another case, 148 AD matter, my lords, issued notice and has kept it to 13th of December.
In Punjab and Haryana.
Yes.
Ah.
Punjab and Haryana. So, the Supreme Court endorsement is not a precedent and is not a res integra. Even res integra. That in due time I'll place. Now your lordship will kindly see the so-called notice is Annexure 1, page 10.
Yes.
Then
reply is 27.6.
Yes.
And order is 29.8.
In this case, I have filed an additional
that's nothing.
Yes, explaining, my lord, the provision 148A(d), my lord, where it in compliance to 148A(d), that is, my lord, clearly says after submission of the reply.
148A(d).
That is after submission of the reply, my lord. That will be waited till the end of that month and then 1 month.
Correct.
That as it shows.
Yeah.
And it is within the, my lord.
How is it? Let's take the first one. Let's take the first one.
That is within that.
Yes.
No, it shows how.
Yes, ma'am. Lordship, I have filed an affidavit.
Forget all that affidavit. Just tell us.
Yes.
Reply was filed on 27 June.
Yes, ma'am.
End of 27 June. End of that month is what?
No, my lord. That is, he had filed the reply 148AC. That is received on in Tarini Minerals 88 Lordship holding.
Yes. 23354.
32 to 36.
His reply was received on 24th August 2022.
24th
August.
Why would his reply of 27 June reach you after 2 months, sir?
No, and it has been sent for electronically.
That was received, my lord, electronically. That was received. That affidavit shows, my lord, record also shows. He had 20. He had sought for extension of time.
Sir, 27 June. He is not seeking extension of time, sir.
No, my lord. He gave another mail, my lord, on 28 June. That is on record. He gave. I have filed reply on 22nd June. That may be considered as my reply. That was given on 24th August, my lord. For that, my lord, that was treated. That reply was given. That reply which was given earlier.
How can that be?
Well, thereafter, that was
what was the occasion for him to give any letter to you on 24th August?
That was given with regard to the initial notice, my lord, not
initial notice.
There is no scope for that. Mr. Mahapatra.
Where is the occasion for him to write to you in August saying, please treat my earlier reply as the reply?
He has mentioned, my lord.
What? Where have you said all this? Where have you said this, sir?
Here mentioned in this mail, he has mentioned with reference.
No, in your reply, what have you said in your reply?
I'm reading, my lord. 148 AB reply he has filed.
Mr. Mahapatra,
my lord.
From your reply. Refer to your reply.
Reply, my lord.
Your counter.
Counter. Yes.
Para 3.
Para 3. Yes. Lordship kindly. On 17 June, however, the office partner to pass the order on which is barred by limitation as prescribed under that has been explained.
They have simply said that the reply, this is also wrong. Under section 148, small c is requiring consideration. Small c will consider the reply of the assessee.
1 minute. Let's go step by step. Where have they said anything about their 27 June reply?
No, my lord, page 4 of the counter affidavit.
Page 4.
Yes, my lord. That is again continuation of the paragraph, last paragraph.
In between, the assessee had filed his reply on 28 June.
The information, yes, my lord, along with supporting materials were based on which proceeding on section 148 of the IT Act has been initiated was provided to the assessee by the order dated office letter dated 31st May 2022. The assessee had filed time petition on 16th June 2022, and accordingly time was allowed compliance to by 16/7/22. In between, the assessee had filed his reply on 28 June 22. Further, assessee had given final opportunity.
What is this? Further, assessee was given final opportunity. What is this final opportunity? The statute doesn't talk of any such final opportunity.
He
7 days,
might have sought
maximum
for,
30 days.
That is, my lord. He had an reply.
No. After his reply was received on 28 June,
yes,
you say further assessee was given final opportunity.
No,
where was the occasion for you to give final opportunity?
Given that, my lord, seeking for time.
No, all that is over. 28 June, you have received his reply.
Yes, ma'am.
Where was the occasion for you to now give him further time for compliance?
Page 4, they have clearly stated, my lords, in between the assessee had filed his reply on 28/6/2022.
Next line is what I'm asking.
No,
Next
that is
line.
here, my lord.
Where was the occasion for them to give you more time? That's what I'm asking you.
After I've given the reply.
That is, my lord, with regard to his further submission of reply for that has been adjourned, my lord.
What? On 28 June, he didn't ask for more time, did he?
Yes, ma'am.
No, where is it?
June reply is with record. Here mail is, my lord, that with regard to in connection with, I am reading, my lord, in connection with the subsequent proceeding with the reference of section 148 AB, consequence to the Honorable High Court's Honorable Supreme Court's order dated 4/5/2022, you are hereby allowed final opportunity to submit the reply. My lord, in view of the Ashish Agrawal's case, my lord, he was given another opportunity.
Did he ask for it? Where's Mr. Final opportunity? He had already filed his reply, sir.
For that, my lord, he gave reply on 24th August. My lord, that will be...
You're going ahead, sir.
Yes.
I am still on 28 June.
Yes.
Did he ask for more time? On 28 June, he filed his reply.
My lord.
Did he ask for more time for filing further reply?
No, but department had to give that.
Where's the occasion? Where's the occasion for department to give more opportunity? Unless he had asked for it, he never asked for any further opportunity.
In view of Ashish Agrawal's case, my lord, again, notice was sent. For that, he had to...
Which notice was sent? I don't know.
Because again, notice was issued.
Was it? When was it issued?
No, specific notice was not that. That notice was to be treated as the earlier notice.
You're confusing, sir. Where was you have written in your reply?
Yes.
That more opportunity was granted to him to file. A final opportunity is granted to him to respond by 20 something.
In view of the earlier notice, madam.
No, where was the occasion for you to write to him saying, please file your final reply?
Now, Annex 1, my lord, space 10, they have mentioned about Ashish Agrawala's case. And accordingly, the notice was issued under section 188 small b.
When?
That is on 31st of May 2022. Lordship will say Annex 1 at page 10.
So that was 31st May?
Yes.
No, and where was the occasion after 28 June? Where is the occasion to give more time? You have said here was given final opportunity for compliance on or before 26th August.
Yes.
Where is that letter?
That is, my lord, here on record.
Where is that letter?
That is on record.
It shows. There's no occasion.
Yes.
On 23rd August, they issued another letter to you, to which you replied on 26th August.
Yes. Mail of 31st May 2022, that is very clear, up to 28th June is given in the.
Kindly consider the said values. Now he says 23rd August. It's a bit dicey. They've created for themselves one escape. They've created for themselves an escape by writing to you this letter, to which you have replied.
Ballots, considering for a moment, ballots.
Yes. Is this the same for all the other two cases also?
No.
No.
This is the first one. Then second case, what is your explanation?
Yes.
Ambika Iron and Steel.
Ambika Iron.
We can give it back to him now.
Ambika Iron ballots. First notice is Annex 1.
30th May.
Yes.
June.
Yes. Then ballots.
Second notice.
Second notice. Where is
July.
the scope? Where is the scope for issuing another notice? Here, just like Mallar's, the previous one.
Again. Sir, all this is a bit dicey because you've given a reply on 30th July. They issued the order on 30th August.
Yes.
All right. The third one? 26.
No, here, my lords, again, my lords, I'll come back to your lordships. Where is the scope of giving two notices? Does the statute prescribe?
What about it? The third one seems more straightforward, sir. Mr. Bapatra?
He has not filed
26752, Sri Metallics.
He has not filed reply.
You have not filed reply?
No.
You have filed reply?
No, we have filed. He has not filed reply to that, to the notice, 148 notice.
He's filed a reply on 8 June.
You have filed a reply.
No, yes. 8 June he has filed a reply.
Yes, 8 June, Annex 4 at page 21.
Here in my affidavit, I have shown, my lord. It is submitted that in the instant case, the petitioner did not submit any reply to the last letter dated 28th August 2022. For that, my lord, it has to wait it. And within 1 month, that has AD.
No, so here again, you wrote to him saying final opportunity. Show us your letter to him. Hmm. 2nd August.
Yes, ma'am.
Same, they give you final opportunity.
Now they have written
Again, on 2nd August, giving you final opportunity.
They cannot. They cannot. Very the manners. Can the limitation be extended? 30 days is the time period. 7 days to 30 days.
Too much natural justice.
Too much. I don't know why they are so kind in this. Well, as examining on the anvil of limitation, well, as limitation cannot be extended either by the assessee or by the department. The time is given. 7 days is the minimum time. 30 days, whether I have given the act. Yes. Lordship, may I kindly see? 148A-D.
Sir, Income Tax Act is a big book. Income tax.
First, your Lordship, may I kindly see? Small b. Provide an opportunity of being heard to the assessee with the prior approval of the specified authority, comma, by serving upon him a notice to show cause within such time as may be specified in the notice, not being less than 7 days. So minimum time is given 7 days. Then, my lords, but not exceeding 30 days. This is the maximum time. Now, 148D. Let me kindly turn to see section 148D. The final order to be passed. Decide on the basis of the materials available on record, including reply of the assessee, whether or not it is a fit case to issue notice under section 148 by the assessee by passing an order with the prior approval of the specified authority within 1 month from the end of the month in which the reply referred to in clause C is received. With the Lordship, may kindly see, from the end of the month in which the reply is referred. There is no scope for giving final opportunity or in that process extending the period of limitation and to giving scope that no, we have passed the right within the period of limitation. So therefore, this, in order to shorten this process of...
No, there's one small thing here, sir.
Yes,
you
sir.
read that 148A-B carefully.
Yes.
But not exceeding 30 days from the date on which such notice is issued.
Correct.
This next line, or such time as may be extended by him on the basis of an application in this behalf.
Yes.
So,
yes.
He's assuming that you have made an application to him saying, give me final opportunity.
Assuming.
He's very benevolently telling you, I'm giving you more time.
If they can assume everything, my lords, I'm helpless. I'm undone. By assuming, my lords, that I will give reply, so I am extending it, or by telephonically asking me, that cannot be also, I am undone. The thing is that, my lords, the assessee has to apply for a particular time, 7 days, 15 days. Then it is again the discretion of the authority granting time. He may refuse also. But that will not give them a handle to give another show cause, like in Ambika Iron, and again in all these cases that you are giving final opportunity. Why? Where is the question after I have submitted in the first case of lordship you have seen, 22/6/2022, I have given, they have admitted it. And now they come with, they say, I have applied. That is completely
What purpose will it serve overall? We are just trying to think aloud. This is 148A regime now.
Yes.
They've given themselves a lot of time now. They know their own department, how it works. So now they've given themselves a lot of time.
Lot of time.
Because they will repeat this exercise. This time they will keep Mr. Siddharth Rai in mind and be very careful. So then they'll come back to the same thing. You will repeat your reply. First of all, he'll repeat his notice. You will repeat your reply.
Yes.
He will repeat his 148 AD. So we're back in square one.
The question is, my lords.
Nothing is, I'm saying we can, even when we interpret all this so strictly.
Yes.
Unless they've crossed that outer limitation altogether.
Yes, they have already crossed. 148A is the outer cross. Outer limit.
Let's say we quash the 148A. Nothing prevents them from issuing another 148A. 1B.
Nothing prevents.
So I'm just saying, where does it take us? They will again repeat a 148 1B. You will again send the same reply. But they will again pass the same 148 1D.
Lordship will kindly agree with me that is in the taxing statute. Nothing can be implied, nothing can be added or subtracted.
No. It must serve. So at the end of all this, it must serve some purpose.
Correct.
What purpose will it serve?
No, purpose. Well, there cannot be any purposive construction.
Not for construction, sir. That is a different aspect altogether.
Yes.
We adopt strict construction. We will say shall means shall.
Yes.
It has to happen within 30 days.
Yes.
This has not happened within 30 days or from the end of the month.
Yes.
Therefore, the 148A goes.
Yes.
What is there to prevent them from repeating this exercise, this time following all the time schedules?
They will be prevented, my lords. They will be prevented.
How?
My lords, they will be prevented because of res judicata, my lords. Already.
There's no res judicata here, sir. This is all notice. There's no adjudication. What is res judicata? There's no adjudication.
Say, Lordship will kindly see. Now, the period is, they have issued the notice. Period is 18-19. Let us say so. The period for issuing notice is 3 years.
No, we'll go to these cases, sir.
3 years. And maximum is 10 years. Then the question of limitation comes. At least I've been able to...
13-14. So 10 years from 13-14, still they have time.
13?
Yes, ma'am.
This is
on year
13-14.
Within 10 years.
10 years provided it is in the form of asset. Where is that?
No, so I'm just saying.
Yes. That is the main question, my lords. And I'll show a judgment of the Delhi High Court. That if it that the Calcutta High Court judgment was a single judge. It is the limitation.
So that's what I'm saying. This is the next part.
Of a single judge of the Calcutta High Court.
Right.
That is Ekax Commerce Private Limited versus ITO Ward 1-1. Considering the submission of the parties and admitted factual legal position which appears on perusal of the impugned order, so and so, I am of the considered view that the aforesaid impugned order is bad and not sustainable in law and is liable to be quashed for the reason that the impugned notice under section 148A under the newly amended act was issued after expiry of 3 years from the end of the relevant assessment year and the alleged escapement of income is below 50 lakhs. They have to get over this limitation. You have to issue the notice within 3 years.
No, here information value is 50 lakhs. Your case.
Beg your pardon, my lords. Which one?
Is it below 50 lakhs?
Which one, my lords?
In these 3 cases, any of these cases?
No, my lords. This, where is the, they have written that it is in the form of the asset.
No, that's a different issue, but here it's not below 50 lakhs, is it?
No.
Just a, I am 26752 or Tarini. First one I am coming, my lords.
It's 17. Covering page it is written. The next page is
23354, my lords.
It was noticed on 56, 2012, amounting to.
So 23354. 23354.
Yes,
my lord. The amount, escaped amount is less than 3 lakhs.
Yes, ma'am.
And assessment here is 1780.
Yes.
Time it is given that is.
Double 354.
Yes.
Your answer. Apart
That is, my lord, in para page 34. That is paragraph 5, my lord. Also, can in view of the instruction of CBDT, my lord, that has been.
There's no one. What does that mean? What is this? What is this instruction?
That is, my lord, CBDT instruction is to follow Ashish Agrawala's case.
No, thereafter limit has been.
What limit?
That has been.
What limit?
Where is this 50 lakh modified? 50 lakh limit has not been modified.
Modified, my lords, to a less to another in this 22 Finance Act, which will apply from with effect from 23.
What have they changed it to?
There is no. It is under the old that 142021. Now they have this modified this limitation 149.
No. On the 50 lakh limit, sir.
Beg your pardon, my lords.
On the 50 lakh, sorry.
50 lakhs.
50 lakh limit.
Yes.
That has not changed.
Not changed.
So I'm saying this case.
That is 3 years.
3 years.
But here that it's beyond 3 years, it's
Beyond
less than
3
50
years.
lakhs.
Yes.
So what do you say to this? Be 3 years, less than 50 lakhs.
That is, my lord, with regard to 11 May 2022, that circular of CBDT,
What is that circular, sir? You don't have it with you now?
No, just
you have that circular, 11th May 22.
I don't have the circular. That circular which has been discussed, well, it is a fact that circular cannot override the statute.
No, but we don't know what that circular says.
Yes, that's correct. Circular was issued on 1st of May, as far as my knowledge is there.
This must be post Ashish Agarwala.
Post Ashish Agarwala.
But 11th May circular is the same post Ashish Agarwal.
Yes.
After that, my lord.
So that repeated this 50 lakh thing, sir.
I'll go through, my lord. Monday, kindly.
All right. Two 3354 of 2022 at the request of Mr. Mahapatra Leonard.
May I pray, my lords? The issue confined. Yes.
Who needs time to produce instruction number 1/2022 dated 11th May 2022 of the CBDT. List on Monday. All right.
Yes.
Now 2388026752. What do you want? You want to save your powder for later?
Beg pardon?
You want to save the powder for later? The other two, 23880267.
They are already annihilated.
All cases may come on Monday, my lord.
Why?
No. These two can get pushed with
Another
item 84.
one is there, my lords. That is a Brahmastra. I'll take you to that brief. On that day, I was a little bit confused. But now, here, my lords, the escaped is 36 lakhs, 43,000, less than Annex 1 or Lordship will kindly see.
Which one?
This 23880. Information was that.
No. Total income is that, sir?
Yes.
No. Unaccounted sale, they say is 48 crores. No. Ambika, you're far ahead. Ambika will not give you that monetary.
Unaccounted sales.
48 crores. This is. That's okay.
No, there I will say.
Both these cases are cases of too much natural justice.
Too much of natural justice. Yes.
That's another category.
I don't know
whether too much natural justice will vitiate the order.
Where do the gates power balance? They have to act within the four corners of the statute.
So if they act like that, then there's no question of us sitting as a division bench, you filing petitions.
Then, my lords, I'll take your lordships to another brief. On that day, I was a little bit confused. That is 17972 of 2022. I have got the brief. It has been.
No. So these will take it now. These two, 238802675 will now sail with that 84 batch.
84?
Item 84.
Yeah. Yes.
All right. So now we come to the main show now.
Main show, no. After this, 17972. 17972 of 2022. That is in that group. I just point out small annexers, few annexers.
Kalinga Institute.
Yes. Lordship will kindly see Annexer 1.
Right.
Page 20.
Assessment year 15-16?
Yes. Annexer 1.
Yes.
Page 20. 148AB.
Right.
Assessment completed under section 1 for scrutiny assessment. Annexer 2 at page 22. Reopening was done earlier. 30th of June 2021, 148. I came to before Lordship. Lordship said that following Ashish Agarwala, you go and appear. Then, my lords, Lordship will kindly see objection to the notice issued under section 148AB annexure 6 at page 58. Lordship got it?
Yes.
Then, my lords, is not relevant. CIT appeal order, not relevant for my deliberation, my lords. Here, yes, is now crystal clear that the objection was given on, and I have given an affidavit that I have filed it electronically. So affidavit again. Okay. Right. Yes, affidavit has also been filed on 9/11. 9/11. Now, the order under section 148A(d) has not been passed. Lordship may see the
25th July. What is the 25th July?
25th
July. They have passed an order.
No. Just that the question also emanated from that day. I again checked up. I have got the brief. Lordship may kindly see. 25th July, my brief. I am giving it, my lords. There may be some confusion at my part.
No. There is an affidavit at flag B.
Maybe
your affidavit.
Yeah.
Dated 28th July.
Yes.
Where you enclosed this order.
Enclosed the order of
25th July. Your own affidavit, sir. This is your affidavit. You have enclosed it.
I don't deny it, my lords, but that is not the order. So, to my instruction is that there is no order passed under section 148A(d).
No, it is, sir. The title itself says that. Proceedings. The title is Proceedings under section 148A(d).
Just a minute, my lords.
I just give this back. We have everything electronically.
Electronically?
We have your affidavit flag B, which is an affidavit of 28th July.
28th of July.
Where you have enclosed a copy of the order dated 25th July. You yourself say that you have got the order subsequently after filing the writ petition.
That maybe for other years, the 3 years pending here, 1 year has gone. Other one is posted to sometime in April. I'll just now electronically. Can your lordship may see if you have small request that the copy, hard copy.
Okay. Sure.
If your lordship may kindly see.
Our own hard copy. Our own hard copies, 17972.
That is my small request to you.
Yes.
I have rechecked. Twice I have rechecked. I may be incorrect also. Annexure 1, my lords.
It's here. Okay. Your affidavit will be enclosed.
Just a minute. I'll check that. I may be
flag B.
1 minute.
Yes, same man. 1516. So let's get to the main matter now.
Yes. Dates would have 25th of July. Yes, I get clarified. Now we'll come to the main matter. Now, my lords,
The judge of Punjab and Haryana has issued notice in some other matter.
yes, in same 148 AD. We'll come to that. Before that, my lords, I'll draw your lordship's kind attention to the judgment of the Supreme Court, which, I mean, this is not a judgment. This, in fact, is an order of the Supreme Court which upholds. And your lordship will show that there is no deliberation of the issue. There is nothing. Nothing has been said. It is only said the High Court is correct in dismissing the writ petition.
Let's read the order.
Yes. Supreme Court order ta diyontu. What the Supreme Court has said in outside. Say that. Ita bahar.
Yeah, the hard copy, Vanshul Jain is there with us. With our paper.
May I replace that order of the Supreme Court, my lords?
Yes.
Challenge before the High Court was the reopening of notice under section 148, capital A, small d of the IT Act. The notices have been issued, after considering the objection raised by the petitioner.
Right.
If the petitioner has any grievance on merit, thereafter the same has to be agitated before the AO in the reassessment proceeding. That's what the Honorable Supreme Court said. And there is no deliberation of issue. Nothing has been said in the order of the Supreme Court. It cannot be treated as a precedent. Now, my lords, say Dalla ye DY Chandrachud order tha. Are Kumar sorry. The relevant page ta kwada wala. Being to your lordship's kind attention to a judgment of the Honorable Apex Court, dated 28th of September 2021 in Maluk Singh and others versus State of Punjab, where this, and I will draw your lordships to the
So this must be what amounts to a precedent.
What is, when it can be treated, because once is a precedent means
correct.
It binds. It applies as a universal law. It applies to all the persons because we have law laid down on Article 141.
These three words are staring at me. Service matters, seniority.
No. What is the principle?
I know.
Time and again.
Right.
Lordship is correct that
Yes.
On the set of acts, then same principle can also be applied here.
Correct. Let's see what the Supreme Court said there.
Yes, para 21. Para 21, page 9 of the judgment. The reasoning given in para 22 and 23 in Manmohan Sharma case, so and so, relating to the case of Danveer Singh would reflect the difference between the doctrine of res judicata and law of precedent. Full stop. Res judicata operates in personam, that is the matter in issue between the same parties in the former litigation, while law of precedent operates in rem, that is, law once settled is binding on all under the jurisdiction of the High Court and the Supreme Court. Just like Ashish Kumar Agarwala. Ashish Kumar Agarwala, the law was of India, Ashish Kumar Agarwala. That can be said, which was passed in exercise of power under Article 142. That is a law, that is a precedent. It is not a precedent. Then I'll come. The law once settled is binding on all under the jurisdiction of the High Court and the Supreme Court. Res judicata binds the parties to the proceedings for the reason that there should be an end to their litigation, and therefore subsequent proceeding insofar as parties to the litigation is barred, and therefore law of res judicata concerns the same matter. While law of precedent concerns application of law in a similar issue, in res judicata, correctness of the decision is normally immaterial, and it does not matter whether the previous decision was right or wrong unless the erroneous. Now, we are not concerned with this. Then your lordship may kindly turn to another decision I am giving. That is, Tika. Tikaram, relevant page. I'll come to your lordships, another decision of the Supreme Court, that is Tikaram and others versus State of UP. Dion Ture bhai. Dion tanku Dion gotade. Para 104, lordship may kindly see. 104. We 104 matters, paragraph, and page 740. We do not think that the law laid down in these cases would apply to the present situation. In all these cases, it has been basically held that a Supreme Court decision does not become a precedent unless a question is directly raised and considered therein. So, also does not become a law declared unless the question is actually decided upon. My lord, got it? Actually, I am very much grateful for this, because this brief, because two things. I had the opportunity to labor.
I know.
Second thing is, my lord, I have been able to appear before a very conceiving judge.
No, it's all right. That part eliminated.
No, that is a hidden secret. That your lordship is hidden secret. So, unless it is appreciated.
See, when you attack my judgment in the Supreme Court, you can't say all this.
Oh, your lordship are already made up the mind.
No, not this judgment. I'm saying any judgment.
That I have not done that corber to go to Supreme Court. I have a very small Your Lordship will kindly see Supreme Court decision does not become a precedent. So also it does not become a law declared unless the question is actually decided upon. Full stop. We need not take stock of all these causes, and we indeed have no quarrel with the proposition therein. However, there is nothing when is not relevant. Then your Lordship will take to another judgment, that is Amit Das. Amit Das judgment kahin? Para kete? Eight. Kete कहलो? दबो ना फटाफट ना हो. Yes, yes, para 20. Yes, balance. That is now Arnit Das versus State of Bihar.
That's juvenile justice.
Yes, yes. Yeah. No. What the obiter? Obiter is
correct.
A decision not expressed, para 20 values.
Correct.
498.
Yes.
A decision not expressed, not accompanied by reasons, and not proceeding on a conscious consideration of an issue cannot be deemed to be a law declared to have a binding effect as contemplated by Article 141 of the Constitution of India. So with great respect, my lords, the upholding the order of the Punjab Haryana High Court, where no issue has been discussed, it is just all right. It not say, it doesn't shut the door for all the assessees. It says, all right, Punjab Haryana High Court has right. Then I will take your lordship, the same High Court, in another matter, and the same judge is sitting with same coordinate bench. Seta diyantu manchanda. Anand.
Supreme Court order.
The Supreme
only Punjab and Haryana.
Punjab, I am giving it. Yes. I am giving it. Punjab, Haryana. Yes. Ansul Jain magutundi. Ansul Jain keshta tangu diyantu. Yeah, ida manchanda. Ida dikha. Punjab, Haryana, ida manchan. Kulwant Singh versus Union of India. I would have dita copy diyantu. Thank you. I met yesterday to my colleagues. I made them
work hard. I know.
Yes.
They must be learning so much from you, sir.
Thank you, my lords. Right, 11 o'clock, they were on this website. Kulwant Singh versus Union of India, Punjab and Haryana. The same bench, Dhingra, Justice Dhingra. The Honorable Division Bench of Justice Tejinder Singh Dhinsa. Dhinsa. Yes, sorry. Dhinsa. I have very difficult to memorize the name of the...
No, the combination has changed.
Yes. Combination has changed. Anyway,
Justice Pankaj Jain was sitting in that other...
Yes. But anyway, it is a coordinate bench. And the coordinate bench was definitely conscious of the fact, we presume that the order has been offered, but still then they have issued notice, granted stay, and the matter is placed on 13th of this month. 13th of December.
All right.
What I mean to drive at is that, my lords, the law, the upholding of the Supreme Court in Ansul Jain doesn't make it a precedent. It doesn't appear in rem. I'll also take to another judgment of the Supreme Court by Justice Ravindran. Ravindran dissent adiyantu. Relevant. अरे कौन करछन मुझे बुझी पाउनी Oof. Lordship to para 23, page 20. By in Booz Allen Hamilton versus SBI Home Finance.
Yes.
I requested one of my junior friends about this topic, and he WhatsApped me. So I could. Para 23. It may be noticed that the cases referred to above relate to actions in rem, full stop. A right in rem is a right exercisable against the world at large as contracted from a single right in personam, which is an interest protected solely against specific individuals. Action in personam refer to actions determining the rights and interests of the parties themselves in the subject matter of the case, comma, whereas action in rem refer to actions determining the right title to property and the rights to of the parties, and not merely among themselves, but also against all persons at any time claiming an interest in the property, full stop. Correspondingly, judgment in personam refers to, this is very important, judgment in personam refers to a judgment against a person as distinguished from a judgment against a thing, full stop, a comma, right or status, and judgment in rem refers to a judgment that determines the status or conditions of property which operates directly on the property itself. Then he has, I think he has referred to Black's Law Dictionary. Generally and traditionally, all disputes relating to rights in personam are considered to be amenable to arbitrator, and all disputes related to rights in rem are required to be adjudicated by courts, public tribunal, and unsuited for private. My lords, the purpose of showing this is that, my lords, the order of the Supreme Court upholding the order of the Punjab Haryana High Court does not create a precedent, nor it can be said that it is a judgment in rem and it it applies to all persons. Because no issue has been deliberated. Right. It doesn't speak about the violation of rules of natural justice, nothing. So what I mean to say, and most humbly submit, my lords, that this cannot be treated as a precedent. Interestingly, I was also going through the judgment of Punjab Haryana High Court, my lords, Anshul Jain's case. There I found that their lordships have relied on the judgments which are all pre-142021 and pre-1489. They have referred to 22 Act. I'm sorry, my lords, 22 Act. One or two, that's like Dattu's judgment, that 357 page Sabilda Sagarala. That judgment, my lords, they have only said that this is a recourse. No, it has not been. Anyway, since the Supreme Court has offered it, we will not say. Well, now the question is, my lord, before your lordship, is whether it is a precedent or not. This is the sole question to be decided by your lordship. If it is a precedent, your lordship will have to abide by it, and all have to. My respectful and humble submission is, it is not a precedent. Had it been that, my lords, the Calcutta Division Bench, I'll also give that order, and single judge of the Calcutta High Court. Beg your pardon?
You've already given that.
Yes, that is single judge now at the bench, who have taken note.
That's it. That's Shivanyana.
Yes, Signam.
Shivanyana.
Huh?
Shivanyana.
Yes, yes. He is a very good judge. I used to read his judgment. Very courageous judge. Lordship know him personally, I think. Here, my lords, in this case, Calcutta High Court case, my lords, the assessee specifically wanted an opportunity of being heard, and that was refused. And your lords, Calcutta High Court, my lords, lordship will kindly see the Calcutta High Court. Page 5. My lords, may be pleased to see page 5 of the judgment. Mr. Samarjit Rai Chaudhary, learned standing counsel, placed reliance on the order passed by the Honorable Supreme Court dated 2nd September 2022 in the case of Anshul Jain versus PCIT in special so. In the said order, the Honorable Supreme Court has dismissed the appeal filed by the SSC after noting that the order has been passed under section 148A(d), after noting the objection raised by the petitioner, and if the petitioner therein has any grievance to be agitated before the AO in the reassessment proceeding, the Honorable Supreme Court in the case was satisfied that the SSC had adequate opportunity before the AO and therefore refused to entertain the challenge to the order passed by the Honorable High Court. Now, my lords, had it been a precedent, just like Ashish Kumar Jain, everybody is bound, because a law declared by the Supreme Court is bound by the by every citizen, every person is bound under that law. Then I have also got a very similar case to what my lords decided in Calcutta High Court. Dinesh Kumar Goyal, Pashupati Ispat ka bhar kar leti. Pashupati Ispat. There, my lord, here, my lords, with lordships, get respect to your lordship. The assessee wanted an opportunity of hearing. That was denied. Denied in the sense, my lords, an order under section 148A(d) was passed. And that's what the Honorable High Court of Calcutta said, that you cannot deny the opportunity of hearing. Then, my lords, that is, my lords, can your lordship take this brief 8217 or? I'll straight take your losses to Annex of 4, page 15. If you're... I'll take your losses only to the prayer portion. It is therefore requested to consider the above facts and documentary evidences, comma, the purchases made from the midst steels are genuine and we are not bogus or fictitious. This was the allegation that I am a fictitious person, as alleged by the by you. Therefore, proceeding initiated on section 148A/148 is not legal and proper, and the same may kindly be dropped. The assessee further requests, this is important, that before any adverse view is taken in the above matter, an opportunity of hearing may kindly be allowed. Instead of giving an opportunity of hearing, unless they pass the order under section 148A(d). That is the fight. So here I have come to your lordships. My lords, I'll take your lordships to Institute of Chartered Accountant versus Ratan Lal. AR 87 Supreme Court bar karantu. AR 87 bar karantu.
It's LK Ratna.
Yes, AK Ratan.
LK Ratna.
Yes, sorry, my lords. Are kaun kuchunno? The Honorable Supreme Court said that it occupies, it will apply to the unoccupied fields of, unless it is ruled out.
Correct, correct.
So 148A(b) doesn't rule out. It says, give an opportunity of hearing. And the legislature has not used any word, shall or may. This says only give an opportunity of hearing. So, my lords, kete para seta 16 na? Question is, my lords, all fairness.
Right.
It is only fairness, which Article 14 is there.
Correct, correct.
Everything has to be examined, as Krishna said, my lord, on the anvil of Article 14 of the Constitution.
Correct.
It is para 16. It is next point out on behalf of appellant that while Regulation 15 requires the Council, when it proceeds to act under Section 21(4) to furnish to the member a copy of the report of the disciplinary committee, so much requirement is incorporated in Regulation 14, which prescribes under the Council will do when it receives the report of the disciplinary committee. Full stop. That it is said envisages that a member has no right to make representation before the Council against the report of the disciplinary committee. Full stop. The contention can be disposed of shortly. Full stop. There is nothing in Regulation 14 which excludes the operation of the principles of natural justice. So the principle is, my lord, the fairness. Nothing but fairness. Every action of the executive has to be fair.
Yes.
That is why, my lords, the legislature, being conscious of this fact, has inserted this clause B. Had not been that, clause B could have been easily removed.
Yes.
File an explanation, you will consider it and pass an order.
Right.
This is not the intention of the legislature. And whether the statute is directory or mandatory, my lords, it all depends upon the intention of the legislature. That is, my lords, I'll show another judgment of the Honorable Supreme Court. Raja, Raja Bulan Sugar, Parakuda, 8, 9, 10. The same principle will only multiply. Same principle. I have got some pain in my back, so I want to take some rest.
No, bro. If you want to sit and argue, you can. If that
No. Definitely not, my lords.
All right. Yes.
Para 8, my lords. The question whether a particular provision of a statute which on the face of it appears mandatory, inasmuch as it uses the word shall, as the present case is merely directly cannot be resolved by laying down any general rule and depends upon the facts of each case. And for that purpose, the object of the of the statute, in making the provision is the determining factor, full stop. The purpose for which the provision has been made and its nature, the intention of the legislature in making the provisions, the serious general inconvenience or injustice by two persons resulting from whether the provision is read one way or the other, the relation of the particular provision to other provisions dealing with the same subject and other consideration, which may arise on the face of the particular case, including the language of the provision, have all to be taken into account in arriving at the conclusion whether a particular provision is mandatory or directory. The respondent strongly relies on the case of state of UP versus Manmohan Lal. Is not that important, my lords. What why I'm bringing this to your lordship is that so, my lords, even if the word shall has not been used, but with all respect and all humility, I'll submit that it is the case that all has to be fair by giving an opportunity of hearing, at least a video conferencing, at least, and uploading. Yes, yes.
No, I'm saying it will be interesting if somebody argues further down the line that this virtual hearing is not a hearing. The statute does not use the word virtual.
That's correct, but that is good humor. Definitely. Then, my lords, no, my main attack is, my lords, is not a precedent, which will not hold us back. Had it been that, after the judgment, after the order of I cannot say that to Honorable Supreme Court that is a judgment, but it is that Honorable High Court of Calcutta, even the same Punjab Haryana High Court, a coordinate bench has issued notice, granted interim stay. Delhi High Court has also, Delhi High Court judgment, Delhi na, hame, Delhi High Court. Acha. Even after these matters, other high courts have issued notice, interim stay, and some have quashed the notices under section 148 AD. So, my lords, had it been a precedent, it would have bound everyone. Just like Ashish Kumar Jain, my lords, even say that Kelminator India, that change opinion. See, 20 care, my lords.
Yes.
There you can say that it is a precedent, because the Honorable Supreme Court said that it is an inbuilt defense, change of opinion, which can be used by the, I think,
now I think others are padded up for too long. See, when the batsman is waiting in the pavilion, padded up.
Sure. But I may say I have not completed
it.
it.
To be the night watchman, my lords.
You are, yes.
No, we want him to be the night watchman. No, I'm not trouble your lordships further with precedents, my lord. But I'd only just add, my lord, to what my learned friend Mr. Ray has said.
Yes.
That the intention of the legislature, my lord, was to reduce the burden of compliance and to reduce unnecessary litigations, my lord.
Right.
Even after GK and drive short, my lords,
right,
which allowed petitioners to file a return and then ask for reasons, my lord, there were certain grey areas left. So the legislature thought it fit to enact a provision where a scheme prior to 148 notices have to be, and it has to be strictly complied, my lords. And I'll just place one paragraph, my lords. I have given earlier, your lordships, a judgment of this Ashish Agarwal's case. Lordship would kindly take up Ashish Agarwal's case, my lords.
No, I think you'll have to give us one more copy because they seem to misplace all the copies that you people give. So today we're going to put this all in a separate folder.
I'm sorry, my lord. May I just hand over one?
Yes, no problem.
I'm sorry for Your Lordship may just take up paragraph 6 at page 10 minutes.
Page 10.
So what I was trying to point out is the legislative intent behind the entire enactment of 148A.
It cannot be disputed.
It cannot be disputed that by substituting of sections 147 to 151 of the Income Tax Act by the Finance Act 2021, radical and reformative changes are made governing the procedure for reassessment proceedings. Amended section 147 to 149 and section 151 of the IT Act prescribe the procedure governing the initiation of reassessment proceedings. However, for several reasons, the same gave rise to numerous litigations and reopenings were challenged entirely on the grounds such as no valid reason to believe, 2, no tangible or reliable material or information in possession of the assessing officer, leading to a formation of belief that income has escaped assessment, 3, no inquiry being conducted by the assessing officer prior to the issuance notice, and reopening is based on change of opinion of the assessing officer, and lastly, the mandatory procedure laid down by this court in the case of GKN Driveshaft India Limited versus ITO has not been followed. Further, pre-Finance Act 2021, the reopening was permissible for a maximum period of 6 years, and in some cases beyond even 6 years, leading to uncertainty for a considerable time. Therefore, Parliament thought it fit to amend the Income Tax Act to simplify the tax administration, ease compliance, and reduce litigations. Therefore, with a view to achieve the said object by the Finance Act 2021, sections 147 to 149 and section 151 have been substituted. Under the substituted...
No, I don't think we need to read all that.
Malath, Your Lordship may straight away come to paragraph 7.
All right.
Thus,
yes.
Thus, the new provisions substituted by the Finance Act 2021, being remedial and benevolent in nature, and substituted with a specific aim and object to protect the rights and interests of the SSC, as well as, and the same being in public interest, the respective High Court, then they commented below that these striking down prior to 1/4/2021, Milord, was not that. So the entire aim, Milord, was to ease of compliance and to cut down unnecessary litigations. In my case, Milord, Your Lordship would appreciate, I'll just take Your Lordship to one, Milord, example which has happened, Milord. Your Lordship may kindly take up WPC 14554/2022, Milords. Lordship call.
Achyuta Nayak.
This is Pataneshwari filling station.
Pataneshwari. All right.
That is, Your Lordship, turn to page 45 minutes. I'm placing this, Milord, as an example, Milord, how application and non-application of mind, rather, is there while deciding whether to initiate a 148 proceeding or not, Milord. Your Lordship would see that this was initially given to Sri Govind Kumar Agarwal, so-and-so, Raipur, Milord. And the PAN number is there. Assessment year is 1718, Milord. Then Your Lordship may turn to page 46, Milords. During the year under consideration, Your Lordship,
yes,
the SSC being is deriving his income from the business being a proprietor of Pataneshwari filling station,
right,
with effect from 15/3/2017. Right. Recognize this fact, Milords. Still, Milords, Your Lordship would come to page 73, Milords. For the year 1819, they recognize in 1718 this particular partnership firm is no more there. It has been taken over by Govind Agarwal. They issue for 1819 Pataneshwari filling station so-and-so, Balangir, so PAN number so-and-so, and they say that these are the transactions which you have to make. And I give a reply to them. If my time, Lord, is, and I have told them, Lord, that this particular partnership firm, Lord, is no more there, and this has been dissolved, and a new the proprietorship concern has taken over, Milords. But still, Milords, they issue me a notice, and they say that this function, Your Lordship, may kindly turn to Annexure 4 at page 53, Milords.
Yes.
My first paragraph says that the partnership firm Partnership Filling Station having PAN number so-and-so was dissolved on 14/3/17 by virtue of deed of dissolution made between so-and-so and Govind Chandra Agarwal, which is duly approved by HPCL, that is a company, loyal company, dated 15/3/2017. But all the same, my lord, now this Partnership Filling Station as a partnership firm, which was non-existent in 1819, has to go and face an assessment proceeding under 148.
Anyway, this is all merits, right?
Now, I'm just humbly trying to say that this particular exercise of partnership, which now partnership, my lord, is now supposed to do, has, my lord, to be eliminated before they do it. And that was the reason why 148A was brought in, my lords, to cut down unnecessary litigations, my lord. And this is a classic example, if I may borrow my word, that word from my learned friend, my lord, to show that there's total non-application of my lords. So if your lordships will not, in my humble submission, interfere with the orders under 148AD, my lord, now partnership for no reason has to face a 148 proceeding, my lords. So in my humble submission, my lords, even if your lordship accepts that the Supreme Court order, be it a four-liner or whatever, is binding on all of us, my lords, your lordships have to, in my humble submission, my lord, consider these cases and decide whether at all these cases are fit enough for an initiation of 148 proceedings.
Question. Sorry for the interruption.
No, I'm sorry.
Only there are two issues before lordship, as I understand. From my argument, and your lordship patiently listening to me.
No, we took him as a leader, my lords.
No, I am not a...
He doesn't want you to preclude patient listening for them.
Yeah, I know that it's a very arduous task. God has not made me. I am very thankful to God. Sitting 10:30 to 4 o'clock. We are able to move in the veranda, gossip, and really it's very... it's a regular punishment.
No, but this is enjoyable. I'm sure
enjoyable
is
yes.
also enjoying it.
Unless you enjoy the work.
Yeah.
You see, then it becomes, even advocacy becomes boredom. Beg your pardon?
Continue.
But Justice Raman is saying.
No, we are keeping our minds open and.
Yes. That is the first thing
active.
that Lord Denning has said, my lords, in his number of books, that mind should be open. That is the English law borrowed by Indians. My lords, what I feel that there are two issues. One is the confirmation of the order by the Supreme Court in Anshul Jain's case will be a binding precedent or not. If it is not, then all are open. Second issue is whether an opportunity to be given as per clause B under section 148. These are the two issues, and let my learned revenue reply. Then we will have the right of reply, members.
Your Lordship, just I want to supplement my Lawrence Senior's another example. Your Lordship.
I don't know if Mr. Kerr has finished.
Yes, Your Lordship, just I'm supplementing another example. How I have to face.
No. Then you will not get any further chance.
Your Lordship.
You want to make up right now. If you interject, you lose that chance. Then
no, we adopt the argument of Mr. Rai, my lords. We adopt his argument. Once your lordship decide on this precedent part of it, my lords, then individual cases we'll beseech your lordships to take it up.
No truncated thing.
No.
So you make all your submissions.
We'll not add to whatever Mr. Rai said.
You make all your submissions. We're not.
We adopt the submissions.
No. One fine moment. One point arguments will stop. No truncated arguments.
Right. Correct. No. I am just waiting for revenue to reply. Sorry. I'm extremely sorry, my lords. I was giving reply by sitting. This is not courtesy. My lords, I am just waiting for the reply.
No, but we'll consider that. But have you finished is the first question.
have
No, I have not
finished.
finished, my lords. I have to show other citations, my lords.
So we're here waiting. All right. At one point in time, we're going to tell you, sir, beyond this.
I'll finish it on coming Thursday.
No. We
Just
will not give you that kind of a time. Now we'll, I think, put the guillotine. So far, we'll accept all your compliments about our patience. But now it's a time to tell you that also has
a limit,
a finiteness.
Okay, then I'll say that I have finished.
We'll say that you can supplement everything in written submissions. All right?
Yes, that liberty may kindly be given.
All right.
At least 7 days time may be given.
Not 7 days and all that. We've made extensive notes. We've got all these things.
No, we'd only pray, my lord, after your lordships decide, my lord.
No. There's no truncated thing like that.
No.
You presume that you have to argue all your writ petitions. That's it.
So your lordship may take these cases where we have shown that it's a complete non-application of mind.
Right.
The other cases, my lord, is in a 148 AD order, my lord. They say it verified to be verified. So my humble contention, my lord, is that 148 AD says, my lord, mandates rather, that they have to decide.
All right.
And there are two cases of mine, my lord, where the entire 148 AD order, my lord, if your lordship permit me, my lord, I'll just take your lordship to those two cases, my lord. One is a WPC 14552 of 2022, my lord. This 148 AD order, your lordship may kindly see. Page 53, your lordship may kindly take up. This was relating to
of anticipating what we're going to do. So it's like this. One is that we are in agreement with Punjab and Haryana High Court that all grounds that you may have 5,000 grounds, 10,000 grounds, and today you may think of some grounds. Down the line, you may think of some other grounds. We do not want to foreclose your grounds. All your grounds, including the ground that this hearing should have been a personal hearing, that this judgment is not a precedent, that all these grounds will be open for you to urge when you are faced with a 148 order, which is adverse to you. We cannot anticipate what that 148 order is going to be.
No, 148 AD.
No. So that when you attack that 148 order,
148 AD, my lords, it is followed by an
notice in form 148.
Correct.
Okay, my lords. There the assessee is asked to file his return.
Right.
Within a specified time.
Correct.
And the reassessment proceeding commences. In the reassessment proceeding.
So two possibilities are, there are possibilities in the reassessment proceedings.
May I be clear to your lordship? Not suppose. In the reassessment proceeding, I cannot again ask for the reasons. I cannot, because already 148.
Yeah, why should you ask for the reasons? I don't understand. Why should you ask for the reasons again?
No, reasons again, my lords, that is previously it was asked for.
No, that was only pre-GKN.
Okay. Then
in GKN itself, you knew the reasons.
After
GKN objections were rejected, you were not asking again for reasons.
Another thing, my lords, just to make time visit. The change of opinion.
All that is available to you, sir.
Cannot be made available, man.
No. We are going to say that all grounds that you can think of under the sun, you can urge. If that 148, there are two possibilities in 148.
Yes.
One is there's no demand at all created. Additional demand.
Additional demand.
If there's no additional demand created in the reassessment, will you still be arguing anything? You will not.
We are challenging.
It's only if there's an additional demand created that you will challenge that order. When you challenge that order, you can attack 148A 1D order with full gusto.
Then your lordship
apart from attacking that 148 order also.
Then your lordship is also is required to answer about 148A small b, which requires.
That's one more ground on which you will attack the 148AD. That is also one more ground.
148A order is always, it has been challenged here in all these.
Correct. And in various grounds, on various grounds.
It has been already challenged.
All those grounds are going to be kept alive for you.
When 148.
We're just postponing it to your challenging the 148 order. If that order is against you.
May I just humbly add, my lords, subject to your lordship's kind consideration. Instead of doing that, my lords, if your lordship would be kind enough to allow us to raise all these objections in the 148 proceeding itself, without being influenced by the 148 AD order, my lords. My humble submission, I've just made 3 points.
Yes.
I'll just read it out to your lordship, subject to your lordship's kind acceptance. That we will cooperate in the proceeding, my lords.
Right.
Raise all issues regarding non-consideration of objections, inquiry, opportunity of personal hearing, question of limitation, and determination of escapement of income with documentary evidence, my lords. And the AO, my lord, without being influenced by the orders passed under 148 AD, my lords, let him first apply his mind and then.
There's no first, second. He will apply his mind.
So
let's not create this additional saying preliminary, middle, final, and all that.
Your lordships have also held that a preliminary objection can also be taken care of in the final.
This is not a CPC proceeding, sir.
So our apprehension, my lord, is that since at every stage this proceeding has monitored by a higher authority than 148 Lord authority, my lords, there may be, my lords, I'll just repeat it, there may be an element of constitutional bias, my lords. So to obviate that, my lords, if a direction from this honorable court goes that this in the 148 proceeding, he will consider all these and also the merits of the case, my lord, my learned friends may also agree to my suggestions, my lords.
I agree. But the question is, my lords, the practical difficulty will be faced. Because
and this is a national faceless assessment, 148.
That's what the other day I was taking to your lordships to clause 8 of clause 5 of 144B. There the discussion is completely left with the Chief Commissioner.
All right. Just to put a last word, Millers, for your lordship's consideration. Yes, I have placed on the last occasion the provisions of 151A, Millers, the scope of faceless assessment. Because there, all the provisions are there, your lordship found, except 148A. This was consciously excluded from 151A. Later that, there will be personal interaction, physical interaction with the assessee, and there will be interface instead of faceless.
All this you can argue, sir. Even this point you can argue.
And one point, Millers. Where the 148A now essentially, Millers, by permitting all of us, Millers, to also place it in 148. Because virtually this is being done away with, but in one sense or the other. This can
only in intermediate challenges are
yes,
done away with. So not that the ground is done away with. The ground is not done away with.
One observation, your lordship may kindly, in the interest of fairness, reasonableness, rationality, all that, let's invent assessing officer finds that the grounds which we could have urged in 148A, now we are re-urging because of your lordship's whatever your lordship.
That's what we said, sir. All grounds,
yes,
including the grounds that you've already urged, including the grounds you may hereafter think of urging, everything.
And if the assessor finds this is acceptable, he can drop the proceeding there and there also. Because he should not assume the power that Ajib he doesn't have any power to drop, he has to continue.
Yeah. We would only pray, my lord, your lordship need not keep this post-48 order, my lords.
We'll see. We just listen to us, then you'll know it. So you say in all these petitions, the challenge is 2:1. A notice issued to the petitioner SSC under section 148 capital A bracket 1 bracket small b of the Income Tax Act 1961 bracket Act. 2, to the consequential order passed under section 148 capital A bracket 1 bracket small d of the Act. Paragraph. While issuing notice in all these petitions, interim orders were passed restraining the department, respondent income tax department, bracket department, from taking coercive action against the petitioners. Paragraph. During the pendency of the present petitions, a coordinate bench of this court delivered 2 judgments. Full stop. One is, which is the other? This is one. Where is the other? One is a judgment dated 6th September 2022 by a division bench, of which one of us, bracket, MS Raman J, bracket, was a member. In writ petition civil 15102 of 2022, bracket, Oro Global Comtrade Private Limited versus Chairman Central Board of Direct Taxes and others. And the other by the same division bench on 27 September 2022 in writ petition civil 17176 of 2022, bracket, Stewart Science College versus Income Tax Officer, bracket, Ward 1, bracket 1. Both of which declined to interfere with similar challenges to the notices under section 148 capital A bracket 1 bracket B of the Act, as well as the consequential order under section 148 capital A bracket 1 bracket D of the Act, by holding that the petitioner SSCs in those cases would have a full opportunity of assailing, of urging all those grounds at the stage of challenging the consequential order in the reassessment proceedings following the notice under section 148 of the Act. Paragraph. Meanwhile, the Punjab and Haryana High Court, a division bench of the Punjab and Haryana High Court, in an order dated 2nd June 2022 in CWP number 10219 of 2022, Anshul Jain versus Principal Commissioner of Income Tax, bracket, held likewise. Full stop. In other words, it was held that there was no warrant for interference by the court at the stage where an order had been passed under section 148 capital A bracket small d of the Act. Some pages are missing. And that all the grounds to challenge such an order could be urged at the stage of challenging the order passed in the reassessment proceedings, consequent upon the notice under section 148 of the Act. Paragraph. The above order of the High Court of Punjab and Haryana in Anshul Jain, Supra, was challenged by the SSC in SLP Civil number 14823 of 2020. Full stop. While dismissing the special, but the said SLP, the Supreme Court of India passed the following order on while dismissing the said SLP on 2nd September 2022. The Supreme Court of India passed the following order. Reproduce the entire order. Paragraph. It has been brought to the notice of this court that, notwithstanding the above order of the Supreme Court of India, the Calcutta High Court has, in an order dated 15 September 2022, in APO 83/2022, Dinesh Kumar Goyal versus Union of India, interfered with an order under section 148 capital A bracket D of the Act on the ground that a single quotes personal hearing unquote was not given to the SSC prior to the passing of the order under section 148 capital A bracket 1 bracket D of the Act. Full stop. It has also been brought to the notice of this court that the High Court of Punjab Haryana itself has subsequently, in another writ petition, bracket Kulwant Singh versus Union of India, bracket, issued notice in a writ petition which raised a similar challenge as in the present petitions before this court. Paragraph. On the side of the petitioners, it was urged that the aforementioned order dated 2nd September 2022 of the Supreme Court of India in Anshul Jain versus Principal Commissioner of Income Tax, bracket Supra, cannot constitute a precedent and is therefore not binding on this court. In support of such a submission, reliance was placed on a large number of judgments, including Maluk Singh versus State of Punjab, bracket, you say Manu SC 0795 2021. Tikaram versus State of Uttar Pradesh 2009 10 SCC 689. And Booz Allen and Hamilton INC versus SBI Home Finance Limited. We'll give the citation. Paragraph. Having carefully examined the said decisions in light of the order passed by the Supreme Court in Anshul Jain versus Principal Commissioner of Income Tax, Supra, add that Arnit Das versus State of Bihar, 2005 SCC 418. This court is of the considered view that the above order cannot be considered be one which does not decide any issue and which has not been passed after considering the issue involved in the case.
That is not audible, Millets.
In other words, this court is unable to agree with the submission that the aforementioned order of the Supreme Court is not a binding precedent. as far as this court is concerned.
So I have given a small compilation, Milord, the other day.
It's all right. All right. Paragraph. This court has also been, the counsel of the petitioners have also assailed the orders, both the notices under section 148 bracket capital A bracket 1 bracket small b of the Act, as well as the consequential order under section 148 capital A bracket 1 bracket small d, on several grounds, including the grounds of limitation, the absence considering of objections, the absence of providing a personal hearing, non-application of mind to the facts, peculiar facts of each case, and several other grounds. Full stop. In view of the fact that, in the considered view of this court, in respectful concurrence with the view expressed by the Supreme Court in Anshul Jain versus Principal Commissioner of Income Tax, Supra, all these grounds could be urged at a stage when an order is passed under section 148 of the Act in the reassessment proceedings, which warrants challenge by these petitioner assessees. Full stop. The court would hasten to add that not only will all the grounds urged before this court in these proceedings be available to the petitioners to be urged a stage of such challenge, but all other grounds which may not have been urged before this court and which may be found necessary to be urged at that stage in accordance with law. Paragraph. Needless to state here that when such challenge is raised on the grounds on which it is raised, it will have to be dealt with in accordance with law by the authority which is expected to deal with such grounds and pass an appropriate order. Full stop. With the above observations, the court disposes of all these petitions and vacates all the interim orders.
Lordships may kindly, your Lordship may kindly grant us some time, Lords, to because the 148 notices were also included in these, Lords. That had a timeline, Lords. So,
okay, you say wherever, but we only said no coercive steps.
Yes, Your Lord.
We never postponed the time for filing replies.
But most of this,
so let's not. Nobody prevented you from filing a reply, sir. We only told them not to take coercive steps again.
No, 148 actions, my Lord.
No. We did not stay the proceedings.
True,
we only said no coercive steps.
Yes, in some cases, my Lord, pursuant to this 148 notices, my Lord,
that is the risk that the assessee took. Sorry.
With your Lordship, may kindly.
No, certainly not. We don't want to disturb that whole scheme, time scheme. It will cut both ways.
I'll only, since your Lordship has already passed the order, I'll only say, my lords, I'll distinguish Caste College, Stuart Science College and Yale. There, my lords, the distinction fact is the assessee filed a return and
I know. Afterwards, woke up a
then he came to the court.
That's right.
Saying that.
Yeah. But ultimately, he was also relegated to the stage of 140.
That is the thing, my lord.
Yes.
That is the thing.
Right.
So once.
That's a growing tribe now.
You have to open everything.
All right.
One small.
Had it been that,
this timeline of one.
I would not have prepared also.
Let's not disturb that whole.
Otherwise, we're not going to cut.
The Lordship kindly.
No. Let's not. In fact, it reminded us, it's so well put by Mr. Rai, that that's a tight time frame which should not be disturbed.
Sir. So, but in most cases, my Lord, since we are before this
no.
court, my Lord, In
There was
most
no
cases,
stay
we
of
have not-
proceedings. There was no stay of proceedings.
With your lordship's kind permission, if my, your lordship, I
It
appear.
was a pleasure listening to all of you.
Say, lordships are passing a common order, my lord, sir.
Yes, yes, it's a common order in all the petitions.
Your lordship's kind permission. Your lordship, I appear on behalf of Mr. Shashwat Acharya in WPC 11065 of 2022 and WPC 12886 of 2022. Your lordship is unavailable today, and yes.
We'll record his presence. It's all over, sir. It's all over.
If your lordship has a kind.
No problem. No, sir, no question at all. Is there a weekly list?
Much obliged.
That's obliged. We are grateful, Vinod.
All right. All right.
Really thankful to your lordship for hearing patient.
No. Please, our pleasure. All right. I'll send you No, I know. Still.
Your lordships are really.
Just realized that we should keep all of you in too much suspense also.
In a way, it's a blessing in disguise for us.
Again, gates are open. We'll again come back.
Yes. Ordinary human beings have plans A, B, and C. For advocates, it goes to plan Z and Z.
But at least at that stage, your lordship will never at least tell us for alternate remedy. That is always there.
All right. I think we'll call it a day.
Much obliged.
Obliged.